Okay, let's kick off. Hello, everyone, and welcome to this discussion on the future of investment protection in the SADC region. I am Michelle Porter-Wright. I am a director and counsel at Allen & Overy in Johannesburg. Let me start by saying I feel very grateful to make this contribution as moderator today to what will be a critical, forward-looking conversation on the future of ISDS and trade policy in the region. And I must say, I do so with a certain sense of responsibility, given we're at such a crucial juncture in our policy direction on this topic. These conversations are certainly essential. And so to help us find our way today, we have four spectacular panelists, each an expert in their field and each in their own right having shaped the landscape of investment protection in the region. So let me make some introductions. I'll start with the familiar faces first. Lise, you have been introduced a few times already. Lise Bosman is, of course, a preeminent figure in this field. She is an expert in investment law and international arbitration. She is a senior legal counsel at the Permanent Court of Arbitration in The Hague. She is an adjunct professor at the University of Cape Town. She sits on the board of ICCA and generally has extensive academic credentials in this field. Welcome, Lise. Svetlana Vasileva. Svetlana is a very familiar face in AFSA circles. She serves as the Secretary General of AFSA International. She brings over 20 years of experience in investment law and in commercial disputes. She routinely manages large international arbitrations in the region. She has an LLM in European Community Law, and currently she is on the cusp of being dual licensed to practice both in Bulgaria and South Africa. So she can assist us with some diverse perspectives on trade policy and ISDS. Then let me introduce Miselo Freedom Kumba. He's immediately to my left. Miselo is an academic and lecturer in the field of ISDS and business law. He is currently based at the University of Pretoria. He's also pursuing his LLD in financial regulation. And Miselo also generally has a very long list of academic credentials in ISDS and investment protection. And last but not least, we have Ambassador Zolalwa Mlumbi-Peter. Zolalwa is a seasoned trade policy expert and negotiator. She holds a BCom honors in economics with further education from Harvard and Yale. She has really held pivotal roles in South Africa's negotiations, both globally and regionally, including a stint as chief negotiator, and she has also been, more recently, South Africa's permanent representative to the World Trade Organization. Her career spans various sectors, including private sector financial services, and she currently serves as Deputy Director General of the Trade Branch at the DTIC. So welcome all, and thank you for your time and contributions today. Okay, introductions behind us. Let me set the scene before I jump in and ask some tough questions of our panelists. So, where do we find ourselves from a policy perspective in the region on these issues? And I think there are a couple bits to unpack there. I think we all know that investment arbitration has fallen from grace in the eyes of sovereigns in the region. There are a web of SADC policy documents which confirm this. Some are 10 to 15 years old already, so this is certainly not a new position. This shift, of course, hasn't occurred in a vacuum. It's a global phenomenon, and I think it's fair to say that investment arbitration has really suffered from a PR crisis amongst sovereigns in recent years. there are criticisms leveled at investment arbitration relative to its infringement on state autonomy, on sovereignty, on states' ability to meet sustainable development goals, on the public interest, on human rights. And so you can see that there's this inherent skepticism among sovereigns on investment arbitration. But we're equally in a position in SADC where we've also lost momentum on regional multilateral forums. The SADC Tribunal obviously was disbanded a couple years ago following a controversial decision to limit its jurisdiction to state-state disputes. There's a COMISA tribunal, but that is not operative yet. And so we seem to have stagnated at the multilateral level as well on these issues. So where does that leave investors? They have voiced some concerns around the sufficiency, the adequacy of domestic remedies, and we will discuss later in detail the role of the judiciary in the investment protection landscape. But looking forward, there are some significant global and continental headwinds which can't be ignored. We have, of course, discussed in detail yesterday the African Continental Free Trade Initiative. That's, of course, striving to create uniformity in trade conditions across the continent. This will certainly shape irrevocably SADC's position on investor-state dispute settlement. You know, and how will that look? Simultaneously, of course, we have global efforts further afield, UNCITRAL Working Group 3, which is critically re-evaluating the traditional rules around investment, arbitration, and damages to make the process more palatable and legitimate relative to sovereigns. And all this, of course, presents new considerations, new opportunities for our region. And so you can see there's a significant amount of complexity for us to unpack here today. So let me jump in. I'm going to structure the session as follows. I'm going to put 2 questions to each candidate. They'll have around 4 to 5 minutes to respond. I intend to run a tight ship in terms of timing. And time permitting at the end, we will have a 60-second wrap-up from each of them where they'll detail their direction of travel or their anticipated direction of travel for the investment protection landscape regionally. So let's jump in. Ambassador, my first question is for you. You have really been at the forefront of South Africa's trade and investment policy. You've witnessed the evolution of SADC's investment protection framework. And let's start with the status quo. How do SADC member states currently balance what is the need for sovereignty and policy space on the one hand with investment certainty and stability on the other? And I think if you could also unpack what role traditional standards of treatment now play in this jurisdiction, if at all.
Thank you very much for those questions, Michelle. One, I think you have already pointed out to the evolution of investment policy making, not only in the region, but also in the continent. And this was necessitated by concerns by states with regards to the impact of the first generation bilateral investment treaties in terms of the impact on the rights of states to govern in the public interest. And we saw a rise in a number of claims with regards to this, especially related to one of the provisions that are found in the bilateral investment treaties, which was the fair and equitable treatment, which was relatively broad and actually amounted to policy freeze, because the way investors interpreted it was that even if you are changing as a government a policy or a law in the public interest, as long as the investor felt that this has an impact on their profits or even expected profits, then they will put a claim. And we saw a number of countries that were facing huge claims. The case in point was South Africa. We were facing 2 using the Swiss bid, as well as Italy. And in the case of the Italian investor, they had bought a farm, and that farm was vandalized, and because of vandalism, because they left it unattended, now there was a claim under the bid. In the case of Lesotho, for example, there was an investor that had exploration rights, and of course the dam was then developed, which services and provides water to the rest of the region, and that investor felt that their rights have been infringed, and there was in fact, Lesotho is still facing a huge claim in that regard. So as a result of this, we had to find a way of reviewing what we had at the time as the 2006 Finance and Investment Protocol. We had to look at how do we, while still providing the rights to investors, because we do need investment, we need to ensure that investors' rights are protected, but this should be done in a fair and balanced way, in a way that preserves the right of governments to regulate in the public interest. So you will find that in the revised Finance and Investment Protocol of SADC, including the model bid, you still have the standard of the historical and legacy standards of treatment that are provided, but they are done in a nuanced manner. For example, we did away with fair and equitable treatment, and we are now providing for fair administrative rights, which means that the investor has a right to administrative and justice at the end of the day. So they have a right to information, they have a right to transparency. If they feel that their rights are infringed, they can have a right to a fair trial. So all of that is provided for. We also had to review the types of rights that we provide. You'll see that the 2016 FIP provides for post-establishment rights rather than pre-establishment rights. We also had to look at the definitions that are provided for in the FIP, including the model bid, in terms of investor as well as investments that is provided. We moved away from asset-based investment definition to rather an enterprise-based definition. And the reasoning behind that is that you want to link the protection that is provided to the enterprise that is actually in our jurisdiction. And of course, any assets that are linked to that enterprise will therefore be also protected under the FIP. So as you can see, we had to find a way of nuancing the type of protection that is provided. We also provide guarantees in terms of fair and equitable compensation, but again, this had to be nuanced to ensure that we look at a number of factors that should inform the compensation in the case of expropriation. For example, current and past use of the property, the history of acquisition, market-based is still there, fair market value will still also be one of the considerations, as well as the purpose of expropriation, extent of previous profits, as well as the duration of investment. And of course, the participants will be aware that this was one of the contentious issues for South Africa because we wanted to ensure that we align the SADC investment regime to also our constitution. In a way that also, and this is not only specific to South Africa, because you'd be aware that a number of SADC countries are facing issues around addressing the historical imbalances, but also addressing the colonial legacies. So it was important to look at how, if we have to engage in expropriation, how do we expropriate in a balanced and fair way that takes into account, of course, the need to ensure that we address those past imbalances and legacies, but at the same time provide compensation to the investors. One of the important, and this is my last point, issue that we had to look into in terms of ensuring that there is balance is the right to regulate and the right to ensure that we are able to amend policies and legislation in a balanced way to ensure that we are able to address all of these issues. So thank you so much.
Thank you, Ambassador. I think you've highlighted just what a delicate balance this all is. My second question to you relates to the use of ADR in these sorts of disputes. You are an accredited mediator yourself. And so I suppose the question is ADR effective? And are investors, are states interested in this for the resolution of investment disputes?
Globally, litigation has been the knee-jerk, if I can put it that way, way of resolving disputes. But I think increasingly because of the need to find an effective way that also accommodates balance, but also win-win solutions, I can see that alternative dispute resolution will be the way to go. I see that especially in the context of trade, given the fact that we have a dysfunctional dispute settlement system in the World Trade Organization. This is now increasingly an area that states are looking into to find resolutions. So I would think that even in the context of investor-state dispute, we will need to continuously explore how we can use ADR as a way to resolve dispute, but still litigation is still seen as the best, especially by investors.
Thank you, Ambassador. Leeds, let me confront you with the same question. I know you have been closely following these global reform initiatives. I know ADR, dispute avoidance, dispute management in the ISDS and an investor-state context is something close to your heart. Can you unpack maybe some of the techniques around ADR that you've seen used globally?
There we go. Got it. Okay, thanks, Michelle. A little bit of brief tech issue there. So I think the reason we're talking about this so much globally, but also on the continent, is partly because of a number of very controversial decisions under the traditional ISDS system, like the PRO forestry system, Ambassador, that you were alluding to earlier, but also sheer numbers, right? And on the continent, we're seeing that not diminishing, in fact, continuing to grow. So if you look at ICSID, the World Bank's administration of investment dispute system, the ICSID system, African states have been the third largest category of states across time under the ICSID system. At the Permanent Court of Arbitration, we see caseloads of states involving African parties increase all the time. And, you know, I mean, under the ICSID system alone, a further 21 new cases were filed over the last 3 years, right? So despite all this discussion about ISDS reform, there's still a number of current BITs and MITs in place that are generating large numbers of cases. So it's really important to actually start talking about it and asking, I think, more creative questions, like how can we avoid some of these cases getting to the level where they become these huge international disputes with parties taking fairly extreme positions on either side, and how can we actually try and resolve some of those disputes at a level where they are more easily resolvable, right? And you know, underlying my remarks is the assumption that in most cases, I think it's actually going to be much more effective to resolve investor grievances, investor disputes at the grievance level, right? And that's going to be better for everybody, for investors and for states. Now, obviously, there are going to be real questions of principle that come up every now and again. And I think those deserve to be resolved very publicly using whatever mechanism we all decide collectively ultimately is the most effective, whether that is international ISDS, whether that's state-state, whether that's the courts or whatever, you know. But the vast majority of those other disputes can really be resolved through good dispute management and dispute avoidance. And I've divided it up into 4 aspects, which will sound quite theoretical, but I think actually they're quite simple ideas, and that's about cohesion, right? So what I see in the approach by many African states to the management of investment and investment disputes is a lack of overall cohesion in the way that some of these disputes are managed or not managed in many cases, right? So 4 aspects: internal cohesion, external cohesion, normative cohesion, and temporal cohesion. Internal cohesion. That's really as simple as a state doing a proper mapping of which investors and investments there actually are in the country, which industries they're in, what the obligations of the states are, and making sure that all the different state actors that may need to be involved in that process know exactly what the state's commitments are, right? And that's done quite effectively by some particularly Latin American states, who will then set up, databases and ways of sort of connecting with investors, but mostly ways of working out exactly what a state's international obligations are and making sure that at every level of government, national, provincial, municipal, that the state actors who have to manage those investments know exactly what those obligations are. Second aspect is external cohesion, which is a big word for simply creating some sort of mechanism that provides for good communication between the state and the investor, right? And the states that do this successfully, they typically set up some sort of dedicated channel for communication between all investors and government departments. So it's a mechanism that has the potential to alert a state when a dispute may arise, sort of at the grievance level. And they also allow a state to monitor patterns of investment grievances, So a state could then actually look and see which kinds of issues are being raised by investors and decide, are more of these grievances arriving in a particular industry or in a particular kind of contracting, right? It gives the state much more control over what is actually happening on the ground with investments that have been admitted. Again, there are some great Latin American examples here. Peru and Colombia have very good systems for communicating between the arms of government and investors. And Korea, for instance, has a dedicated ombudsperson whose job is to deal with exactly those complaints at the very early level. Third aspect of cohesion I see would be normative cohesion, and that's a state committing to periodically reviewing its international obligations and making sure that its national legislation is consistent with its international obligations, but also that its international obligations are properly accommodating national policy objectives, right? Because where there's a difference between those national policy objectives and obligations that a state may have entered into, inevitably disputes are going to arise at some point. And the last thing is temporal cohesion, cohesion over time. I think one of the things that really besets this issue of this challenge of managing investment disputes is the fact that we have on the one hand investments that in principle are made for a very long period. You would assume that most investors are in a country to, investors properly defined, or in a country to stay, for 10, 15, 20 years. And yet the local political election cycle is typically 5 years or 6 years, right, with potential changes in policy. So there's a real challenge in trying to actually create policy consistency across time. And another Latin American example I'm familiar with is Costa Rica. What they did was to establish an independent investment protection commission, right, which operates outside of a government but reports to and communicates with arms of government all the time. It logs investments, logs claims, meets regularly even when there are no live disputes taking place. And it exists simply to actually try and create policy consistency beyond the short-term election cycle. So I think, by paying attention to all four of those aspects of cohesion, we can really make serious strides in avoiding some of the more frivolous claims, or the claims that really are a misunderstanding or a result of poor governance. Get rid of those at a sort of early level and leave a state free to use its valuable resources and time in litigating or arbitrating or resolving in whatever public way is necessary the real issues of principle.
Some really valuable guidance there on how to foster cooperative relationships between investors and states, obviously in a bid to avoid disputes. So thank you, Lise. Lise, my second question to you relates to the global reform initiatives underway and how they might relate to SADC. And yesterday we were chatting around the Advisory Centre on International Investment Law, and I'd be great if you could unpack some of that for the audience and its implications for the region.
So I think many of you will be aware that that UNCITRAL, the United Nations Commission on International Trade Law, does quite a lot of work both on commercial arbitration, but more recently also on ISDS reform in its working group 3, right? It's not the only group that's been addressing the issue of ISDS reform. There are lots of fora, including the African Union and African Continental Free Trade Agreement discussions. And there are other international organizations that also pay a lot of attention to it, you know. So I think some of you will be familiar with the work of UNCTAD, the OECD, the IDLO, the African Union, and the World Bank, right? The World Bank, for instance, has quite a useful package of materials, which they call the Systemic Investment Response Mechanism, which is being rolled out at a kind of pilot level in a number of countries, which is aimed at identifying and tracking and ideally trying to resolve investor grievances. So given that background, there's a lot of thought going into how to actually create proper advice for states at a sort of early level. But Working Group 3 has been very focused on it. It was established in 2017 with the goal to really examine all the issues that have been raised around ISDS reform, some of which the Ambassador mentioned earlier, right? And there are 3 key plans that are emerging from this discussion, which are becoming fairly concrete. The first is setting up an advisory center. The second is developing guidelines on the prevention and mitigation of international investment disputes. And the third is a potential standing mechanism to resolve international investment disputes, this international investment court, if you will, which may be comprised of both a disputes tribunal and an appeal tribunal. But those discussions on the standing mechanism are really nowhere close to conclusion, so the sort of final structure is not clear. But what is much closer is the Working Group 3's advisory centre. So there were what were supposed to be final discussions at Working Group 3 last week in New York, and the decision has been taken to put it forward to the UN Commission in July of this year and sign off on it, right? So it really is very close to actually being launched. It will have 2 primary functions. One will be an advisory function, which will advise on dispute prevention, provide training, capacity building, hold seminars, act as a repository for states to actually share their experiences and of best practices. And then in its legal function, what it'll also do is get involved in actual ongoing investment disputes, right? And the kinds of things that have been pulled out as services that it will offer will be assessing actual cases, selecting adjudicators, supporting states in preparing submissions, facilitating the appointment of external counsel, etc. So it has in principle all been signed off on and we think be approved in July. It has left a number of really important issues open, such as whether it will also include state-state dispute resolution within its scope, such as where the seat will be, such as what its exact relationship to the UN will be. Will it actually act as a UN body or will it be completely independent? And very importantly, I think the categorization of member states within the advisory body system for the purposes both of assessing contributions and prioritizing member states for receiving services. So there are some undecided issues which will be left to the governance of the actual center rather than the political actors, interestingly, you know. But I think there's a real desire at Working Group 3 to actually move things forward because, you know, the process of Working Group 3 had just expanded all the time. So that's quite concrete. So that's what's happening at a kind of international level. Do I have 1 minute more?
Yeah, go for it. I think we're good.
There's something very similar happening under the African Continental Free Trade Agreement, right? Okay, so the investment protocol foresees a mechanism that is not unlike the advisory center. So it has established or will establish a Pan-African Trade and Investment Agency which will provide technical support. And it also obliges member states of the Continental Free Trade Agreement to put in place some of these dispute resolution mechanisms that I've been talking about and to support the work of the Pan-African Trade and Investment Agency. I think that's really challenging for many African states. There are some states that are doing really well in terms of of managing disputes. Egypt's got some mechanisms. Nigeria has an investment promotion commission that does it quite well. Kenya does it as well, but most African states actually don't have the mechanisms in place to do the tracking and the monitoring of investment claims. So getting back to the SADC region then, I think we are going to see SADC countries having to actually participate in the new Pan-African agency and put in place some of these dispute avoidance mechanisms that hopefully will avoid a number of live contentious investment disputes that, in my view, shouldn't have ended up being disputes.
Thanks, Lise. I think that's certainly exciting, the prospect of that centre, and it's great to see such a level of creativity in the policy making on this. Svetlana, I'm going to put that question to you for a different angle. Particularly interested in the EU perspective, given your qualifications. How are the international reform movements set or poised to impact SADC?
But also my point of view will be based on my experience as well, because I also act on a couple of investment projects matter to represent parties. So mine will be only practical view compared to my colleague here. So considering the ongoing global reform movements and their implication for the SADC, it is evident that the Southern African development community is on the critical juncture, considering its investment dispute resolution framework and mechanism. How the global trends might impact SADC and what opportunity they can offer. First, I think SADC should embrace the international standards and practices. The ongoing international reform efforts, particularly this of Ancestral Working Group 3 that Liz mentioned, highlight a global consensus towards making the investment state dispute settlement system more transparent, impartial, and inclusive. For SADC, this global momentum presents an opportunity to revise and strengthen its investment dispute resolution framework. By aligning with these global reforms, SADC can ensure that its systems is seen as legitimate and fair by both investors and the member states. For instance, the adoption of the Code of Conduct for arbitrators, as discussed in the ancestral reforms, could be a significant step towards enhancing the credibility and integrity of the arbitration with the SADC region. On the second place, I will say that striking balance between the sovereignty and investor protection is crucial. The global trend of aligning the investment treaties and dispute resolution mechanism with the state's sovereignty will also safeguard while also safeguarding the investment rights, will offer promising path for SADC. Driving inspiration from the models such as the European Commission Investment Court system and the public law approach to investment treaty arbitration, which emphasize the transparency, accountability, fairness, and justice, which restrain investor protections, SADC also has the opportunity to refine its investment landscape by incorporating explicit clauses that validate the state's authority to legislate for the public welfare, encompassing environmental sustainability, public health, and social welfare. This strategy aims to ensure that the investment dispute resolution upholds the public law principles akin to this in domestic and international courts, and in that way also safeguards the regulatory sovereignty of the governments without compromising investors' protection. The third point for consideration, considering alternatives to the traditional investment state dispute settlement system, could be using, for instance, regional investment agreement like African Continental Free Trade Area. This type of agreements can harmonize investment protection across the regions and integrating the regional development objectives into the investment frameworks. The second or another alternative is using the investment chapters in the free trade agreements, where can be outlined the investors and the state's rights and obligations, and ensuring the investment protection does not compromise regulatory autonomy. Another alternative to traditional investment state dispute settlement also could be using the national investment laws. The next option is using the voluntary principles and guidelines. These not binding tools, for instance, from the international bodies can influence responsible investor behavior and support sustainable investment. Next could be the state-to-state arbitration as another option that offers states greater control over dispute outcomes. And finally, as alternative, could be promote mediation and other form of alternative dispute resolution as amicable and cost-effective dispute resolution. My fourth point is that in the SADC region, capacity building and the legal infrastructure development need also to be boosted by forcing and developing legal expertise and strengthening judicial systems. Initiatives such as training programs for the legal professionals, also initiatives such as for the judicial collaboration and the establishment of the specialized court and arbitration centers could be a key for the efficiently managing the complex investment dispute in the region. This approach will not only enable SADC to navigate the global arbitration landscape more effectively, but also strategically to use arbitration to protect the interests of its member states in disputes with the foreigner investors.
Svetlana, I'm going to need to stop you there because I want to ask you a second and related question.
If I just can conclude
No
on
problem.
that. So, in conclusion, the impact of the global reform movements present challenges and opportunities. But by adopting these reforms, SADC has the opportunity to improve its investment protection framework and make it more transparent and aligned with the sustainable development. The focus should be on adopting global best practices while tailoring them to meet the unique needs of the SADC region. And in that way, strengthening its position and as an attractive destination for investment with the framework that safeguards the interests of both investors and the member states.
Thanks, Svetlana. You obviously sit at AFSA, so you've got a good view here. And of course, we've seen at this conference the strengthening of regional initiatives on administered arbitration. You've touched on the answer already, but I wonder if you want to give us a quick whistle-stop tour. Does administered arbitration offer a good alternative to an ISDS system, and what are the dynamics we need to unpack there?
Definitely, and I can speak from the pure point of AFSA, but our international rules, they can accommodate investment arbitration, and backing with International Arbitration Act, we are fully equipped.
You've given us a great overview of sort of the capacity building that's required to get that off the ground, so thank you. Let me move to Miselo. Last but not least, Miselo, you are prolifically published in a number of the questions I want to put to you. And first, short and sweet, does SADC still really need its own ISDS system?
Just from the outset, there are two conclusions that I would like to make regarding this discussion. One is whether we condemn the ISDS or we praise it. It is likely to still remain in place and continue. The second conclusion is that if even when we establish the investment court, the suggestion that the European Commission is suggesting, it is likely that the controversy of the ISDS system will continue to remain. And so that means I will have a prolonged career of writing in this kind of area. And so for me, how I would like to try and answer your question is to say, first of all, it's in three ways. The first way that I would like to answer the question is, first of all, why was the ISDS established in place in the first place? So that we see how useful it is in the first place. The second way to answer your question is the institutional design of the ISDS system at the ICSID World Bank, as Professor was describing it. The fundamental flaws of it, which are the root cause of the problem of the legitimacy crisis that we are now facing. So that's the second way in which I would like to answer your question. So the first leg of it is this. The ISDS system, the arbitration system, was established in order, first of all, to attract foreign direct investment. So the idea that if we protect investment, we are going to attract foreign investment in a particular jurisdiction. So this is an economic development argument. And so that is found in the preambles of bilateral investment treaties, but that is also found in the ICSID Convention, which is the very founding rules of the arbitration system. So that's the first reason why it was found. The second reason was to displace the national courts, and that is to delocalize the investment dispute. What is that? What exactly that look like? Is to say that the national courts, regardless of how efficient they are perceived to be inadequate. And number two, that the role of the national court is they have essentially been turned to be an enforcement agencies, rather than having any review role of the awards that are rendered by the ICSID arbitration system. So you can already tell that this is a fundamentally flawed procedure. The second way, talking about the delocalization of the dispute, is that the ICSID system does not have an appellate mechanism in it. So what they have is a self-contained regime of annulment. That is a narrow review process that is strangely unique, that is looking at some few grounds of review in order to determine whether there was corruption in the award, or was the tribunal properly constituted, or things like that. So what you see is that the error of law, like you would find in a functioning and proper judicial system, is not something that the drafters of the convention were concerned with. And that is to say, already that tells you this is a fundamentally flawed system. The idea that there's no appellate mechanism. So that's the second reason. I think that the third one is this one. That is the idea of depoliticizing investment, dispute settlement. What that means is this: we are going to make sure that we move away from the diplomatic protection difficulties that are associated with the idea that if a small, medium enterprise from China is having a problem with the way its investment has been treated in Africa or in South Africa, and so it has to engage the government of China to decide out of its own discretion if it wants to challenge South Africa or not. And that gives practical difficulties because of economic relations that China and South Africa has, and that is the problem of the problems of diplomatic protection. And so what has been praised as the success of the ICSID arbitration system is to say we have to do away with that diplomatic protection. So we depoliticize it. So there's no intergovernmental arguments in place. So those are the type of the reasons why we have established the system. But the challenge is that the entire system is inherently problematic. It is problematic in its institutional design. It is problematic also from the substantive provisions of the treaties that countries have signed. We saw from South Africa that South Africa signed these old bilateral investment treaties. They did not know even what they were signing, or that the World Bank told them to sign them. So those are the reasons for the signing of the substantive provision. And what we see now from the reforms that are taking place at the UNCITRAL level is the participation of SADC member countries to that reform process. What you see is that there's only one submission by the members of the SADC. It's South Africa's submission. And it's a curious submission that it makes. It says that countries have to decide if they want ISDS or not. They have to consider if ISDS is necessary or not. That's the consideration that South Africa is making. Say, it's up to you. We have elected our choice and say our judiciary is functioning properly, so it's up to you to decide. But in your deciding, you must look at the historical origin. They also say that in your decision also, you must not just assume that you can plug in ISDS system in the drafting of the treaties. You must think carefully about this. And then this is the last submission that South Africa is making. It says that we have to look at not only we should not divorce substance from procedure. South Africa says that we have a problem of substantive obligations that are contained in the treaties, and we should not take them away from the procedure. And that is exactly, if I can summarize that is the two-pronged problems. The first one is this, that there is a lack of clarity in terms of what the substantive problems are. Substantive obligations are. And this is because these were imposed on African countries. That is, the standards were themselves imposed on African countries. That's the first one. The second is the problematic nature of the ISDS system that I have described, and it goes beyond the institutional design. There's a problem of double-hatting, whereby the arbitrators themselves sometimes act as counsels for the multinational corporations. And the other factor, I think this is also important, is that the way the system is designed is this. We are not allowed as a state, even though it's called an investor-state dispute, the state cannot initiate a dispute against an investor, regardless of the actions of these multinational corporations. So the questions of whether that can be sustainable in the present-day world is one that is very challenging. So that means that the people who are affected by the project of the actions of those of the multinational corporation, the displaced local people cannot go to the arbitration, but the investors are third parties to the agreements. They themselves did not sign the agreements. The agreements were signed for their benefit. Why not taking the local communities and give them a fair chance there? The other problem is this one of the state not being able to make a claim except counterclaim provisions that are provided. So what you see is that is inherently problematic. It provides unilateral protection to foreign investors. It does not provide protection to the other parties, any other stakeholders. And the reason for that is that was the very idea, but it's very unsustainable in today's world. Thank you. I was just pressed for time, so I have to speak very fast.
Miselo, you very eloquently set out, I think, a number of the concerns of sovereigns on the ISDS system more generally. You've already mentioned at a high level the role of the judiciary and domestic courts in ISDS and whether they offer adequate protection to investors in the area. Can I ask you, and I know again you've published on this particular issue, can I ask you to unpack some of the dynamics around the court system and its role in ISDS?
That is also an interesting one, but it's also linked to the previous discussion, because the role of the local courts is an important one because of the sovereignty of the state. So the judiciary of the state is the arm of government of the state. And therefore, if you empower foreign investors to overlook the judiciary, the entire judiciary of the country, and give them only the unilateral power to initiate dispute at an international level, what you have done is you have undermined the sovereignty of the state. That's the first issue. So to displace, you have to have good reasons. It's almost unjustifiable why you would do it. It's a very, very tricky question. So that's the first one. The other question is that I think we had discussions yesterday where there has been problems in Nigeria and African countries in general, the perceived inadequacy of the judiciaries, how they function. You see, that's the other problem. So the other problem is a problem of expertise. And that problem, I think, it's no longer, it doesn't matter anymore, because if you can look at the discussions that are taking place here, that problem of expertise just goes away. We can't really say that Africans are not they don't have expertise in this particular area, and judges are not trained in investment law and all of that sort of argument. I think it just falls away. Based on this conference alone, we can see the vast amount of expertise that we have. So the role of the courts then becomes important. The other consideration of that is the argument that was raised yesterday is that what now do we do if we say an investor is going to challenge the state but goes exactly to the state's court of the whole state to challenge the very same state? You see, that's the problem of bias, perceived bias. It's a problematic one. And I have suggested the way of balancing that. It's not a perfect solution. To say that we have to look at the principle of customary international law called the exhaustion of local remedies. To say that we give a fair chance to local courts to exhaust local remedies up to the highest court in order to determine if the system, local system did not give a fair chance in terms of the judgment it rendered, the investors still feel aggrieved. They can then take to the international arbitration. But the problem still with that is that you are giving a review power to international arbitration, party-appointed arbitrators that we don't know where they come from. You give them a review power of the entire court system. So that's what makes now the exhaustion of local remedy requirement an imperfect solution to this problem. So in short, this is why I was saying from the beginning that this problem of ISDS seems to have no solution and is still going to remain. Thank you.
Thank you, Miselo. We have 5 or 6 minutes left, and I want to use that time to ask each panelist to give us a 1-minute précis of perhaps an elevator pitch, if you like, on our direction of travel regionally. Is it domestic courts? Is it regional forums? Or is it international arbitration? Miselo, I think I have a steer from you. Do you want to kick off?
The direction from the SADC region is a confusing one, because what we have is, as a result of the Campbell controversial Zimbabwean case, there was a removal of ISDS at the amended annex of the FIP, and South Africa also supporting that with its Protection of Investment Act. They removed the entire remove. So the policy position at that level is clear. But what we do not have is the actions from the SADC member countries. Indicating what direction are they taking. Because what you will see is that Zimbabwe, for example, passed an act called ZIDA Act. It contains, under the new regime, I think they're cleaning the problems of Mugabe. Under the new regime, they are trying to now attract foreign investors, and there's ISDS system in the legislation. But also, South Africa's inconsistent position also. You see that South Africa has an ISDS system with the Zimbabwe Bilateral Investment Treaty. So you just don't know which direction they are taking. The other problem is that beside the removal of the ISDS from the treaty, there is ISDS system between outside countries. Remember, the principle of international law says that you can't have a binding, the treaty is only binding only to the parties to it. So that means that the SADC treaty is binding to the members of the SADC. But now, what if now Zimbabwe or South Africa has a treaty with the United Kingdom? That means that that treaty is still applicable because it cannot be terminated by the decision of the SADC region. I think it also goes to the protocol that the panelist was discussing yesterday, that you can't, there is a suggestion at the continental level to say we are going to terminate treaties within the 5 years after the operation of this. But which treaties are you going to terminate? Because you can't terminate the treaties, a lot of old problematic treaties that countries have signed with European countries and other countries that are outside Africa, because that is, that you have no power to do that. So I think
it's fair to say that your answer is it's complicated.
It's very complicated.
Is that right?
Yes.
Lise, are you going to pin your colours to the mast on
I'm going
this?
to make 3 remarks. I'm not pinning anything to anything at this stage. I think it's very clear how contentious this whole discussion is, right?
Yeah.
You know, states already are divided into 3 broad camps. You know, 1, keep the system; 2, reform the system; or 3, or pretty much replace it, right? Because it's fundamentally flawed, is the argument. I don't know what's going to happen in this region. I think we are going to keep some elements of ISDS, partly because there are these old historic treaties in place with non-African states, which can't be terminated without consequence. I think, and again, this is an issue of power. It is possible to renegotiate some of those treaties. The European Union, for instance, member states have been forced to renegotiate the vast majority of their treaties based on new model BITs. And again, but it's a question of power and getting access to the right forum. So it will continue to some extent, number one. Number two, again, a plea for avoiding getting there in the first place. I think if we put in place the mechanisms to try and avoid all the frivolous and really non-principled complaints or issues, we can avoid a lot of these discussions. And the third thing to flag is we talk a lot about treaty-based arbitrations. We're forgetting about the contract-based arbitrations, of which there are many. We see it in the PCA's caseload. The proportional percentage of contract-based versus treaty-based cases is increasing all the time, both proportionally and in absolute numbers, right? And that's going to depend on what the parties put into those contracts. Those huge mining concessions, for instance, is there going to be a referral to ISDS? Is there going to be a referral to the national courts? And that's another area for people to actually think about, for negotiators of contracts to think about very carefully what they want to include.
Svetlana, where are we headed?
Of course, I'm biased. I will say arbitration. And my point is, if international commercial mediation make its point like the best way for resolving the commercial disputes, why not this to be applicable for investment arbitration as well? And I think, like, as matter of urgency for SADC, they need to decide on the investment dispute resolution framework and dispute going forward.
Thank you. Ambassador, great to get your views.
A minute is not enough. But anyway, I'll make 3 points. One, I think the issue of the ISDS, as has been said, is the issue of legitimacy, especially the first generation. So definitely the system needs reform. And it has to be reformed in a way that creates balance, rights and obligations for both the state as well as the investors. 2, we do believe that when it comes to resolution, especially when the issue at stake are legitimate measures by the state to govern in the public interest, that state-to-state arbitration is the best way to go. And the reason behind that is that the state will be more sensitive to legitimate rights that it also, in its own home state, would want to still preserve. So there is a need to consider that. And the third issue is the importance of exhaustion of domestic courts, because what the system has done, which has also contributed to its lack of legitimacy, is undermining the domestic court system. Maybe the last fourth point is that given the importance, especially now we see a lot of, the West, of course, was of the view that ISDS is the best. But now with issues resulting from the need to protect and take action with regards to climate change, a lot of states in developed countries are realizing the risks associated with investor-state dispute, and they are also reviewing their own investment regimes. So what is going to be important is to look at how do we ensure that we find alternative dispute settlement systems that will ensure that we find win-win solutions going forward. Thank you.
Thank you. Thank you to all 4 of you. We've covered a lot of ground. And unfortunately, I don't think we have a clear answer to what are some very complicated issues. But we have to watch this space. But we have certainly seen some very clear thinking from all our panelists on the dynamic in the region. So thank you all for your time, and goodbye.
Let's get started. Firstly, introduce myself. I'm Clive Ramsey. I'm a director at Cliff Decker Hofmeyr, CDH, and I head up the construction sector at CDH. Thank you very much for joining us this afternoon. I know you had an option of A or B, and thank you for coming to our lecture and panelist discussion. Firstly, I'd like to introduce you to the members of our panel. Very fortunate to have representatives from Kenya, in particular from Kenya, joining us. So let me start with Jacqueline Waheya. Jacqueline is an advocate of the High Court in Kenya, and she's the managing partner of JMM Law. She's also the chairperson of the Chartered Institute of Arbitrators for the Kenyan branch. She's qualified ADR expert and chartered arbitrator for the Chartered Institute of Arbitration and holds an advanced certificate in construction adjudication. She's also been a recipient of several awards, African Woman Leader Awards in 2023. Jacqueline will give us her views and the evolution of the international arbitration in the context of Kenya. Moving on to my direct left, Veronica Connolly. Veronica is a senior associate at CDH. She's an English and UK qualified solicitor. Early formative years at Clifford Chance in London. She has substantial experience in international arbitration, and we're going to hear from her a perspective of a UK solicitor now residing here in South Africa and having her experience of arbitrations in Africa while she was in the UK. And then my partner, Kaya Matengu. Kaya is a director in the construction sector at CDH, and again has substantial experience in the construction, in particular arbitration adjudications in the SADC region. And he will give us his perspectives in the SADC region of arbitration and how it's evolving and how we are prepared and are we prepared to go forward. And then Kim Olafir. Kim Olafir is Associate Director of Control Risks. She's been with the company for 16 years. She's practiced in the UK and been in South Africa on the whole idea of e-discovery and general technology advancements in arbitration and how they assist in the arbitration process. And again, can they be used into Africa? Or is there something uniquely European, the use of technology in arbitrations? And she'll take us through and her experience in the years that she's worked with the company Control Risks. So let's I always try and find a quote, and the one I found is, "Success is where preparation and opportunity meet." And today we're talking about looking at international disputes in the evolving legal environment, and is Africa prepared, and are Africans prepared? So I'm going to start out with Jacqueline. The first, and you've got a set of slides, so I will provide you with your clicker. It should be working. Is that right? If you click to the next slide, should be your... Oh, all right, we need 2 seconds.
Okay, I think while we're waiting,
Yeah.
Thanks for the introduction.
Thanks, Jacqueline.
Yes.
The mic's not...
Okay, you can
Okay.
you can hear me? So, and I
Thanks,
can
Matt.
click, right?
Yeah.
Okay.
In leading into your slides, Jacqueline, one of the things is, has there been a shift in the legal environment from a Kenyan perspective? If you have a look at your experience in Kenya, in the international disputes, has there been? And if you could take us through your experiences and what you've seen in the last number of years in the Kenyan, in
Okay.
Kenya.
Yeah, so thank you, Clive. I think we could look at the trajectory from, and I think I'll start from where CIR emerged in Kenya, and we've been in Kenya since 1984, which is about 40 years. And what I've seen in the Kenyan context particularly is that in 1984, of course, it was very private. It was by contract. And it wasn't until about 10 years later, in 1995, when we got the first Arbitration Act, and that became active. And through that, we were able to mobilize quite a number of trained arbitrators in ADR, and they were initially predominantly from the built environment. And eventually, because of the legal aspect or the legal inclination, we also had lawyers becoming arbitrators as well. So right now, I think the first thing that we would say is that arbitration, whether domestic or international in Kenya, is handled by multidisciplinary professionals, predominantly lawyers, about 60%, and we also have quantity surveyors, architects, and we also have engineers as well coming into the fray. What I'd like to say is that in addition to this, we have also now acquired an international perspective from what we had seen in the earlier periods, particularly since in 2010, Kenya got a new constitution. And in the constitution, we like calling it the Article 159 2A. It's the alternative dispute resolution clause. And the clause really gave us a firm foundation, and it also gave us an in-way into the judiciary as well. So, you know, court intervention is pretty key to ensuring that arbitration not only takes, but it is also enforceable. Our act includes the New York Convention, so enforceability has been an issue. Now, coming to today, what I can say is that, and I've really mostly spoken about the personalities involved in the space, I can tell you that currently our judiciary is very highly competent also in our qualifications. I can say without fear of contradiction that our entire Supreme Court are now fellows of CIAB. So too, almost all the members of the Court of Appeal, and we're also getting a lot of interest from the High Court. Now, CIAB is key in training. I think that is probably the main area where we engage in. We train, and we've been training the judiciary, we've been training the lawyers, we've been training the professionals in the built environment. So you find that there's more wholesale adoption of ADR, including it in our contracts. And the key effect that we have seen is that we also have the dispute resolution clauses being incorporated, particularly for domestic or domestic come international parties. We find that they include the dispute resolution clause, which makes CIAB Kenya the default nominating authority. And of course, now that we've come to AFSA and we've enjoyed the last 2 days in the conference, the one key takeaway is that everybody is going regional, and I think we too in Kenya are heading in that same direction, and we're looking for collaboration so that we can ensure that we are able to share the competent ADR professionals that we have, and also the benefit of the jurisprudence that has emerged. Of course, when we move to enforcement, the courts have been very, very supportive, and what they have done is that they are very accommodative of ADR decisions. That is for construction adjudication and also final award. So the binding nature of arbitration is very respected. So there are some gaps. We haven't gotten there completely yet. So the one key area is that, and I've seen that is addressed in AFSA's international rules, that is the third-party funding. We're still talking about it. We are still thinking about it. We are still in the implementation stage, and I can assure you that we'll be borrowing a lot from what I've seen, that you have your rules here together with the multi-party disputes and a lot of very innovative things that we have seen here. The global legal shifts, I think they affect all of us without exception. And one of the things put there about innovation and disruption, we had a very interesting presentation in the earlier session by KPMG on technology, very eye-opening. And I think it's not going to end there. We can expect artificial intelligence and now the shift towards artificial general intelligence to be a huge disruptor. And when we compare this with what we are seeing with, and I think we also talked about ESG, climate emergency, there is a huge shift that is happening in the way we contemplate what we thought were very basic issues or fundamental questions. I think also the closing of the gap between civil jurisprudence, the civil law and common law jurisprudence is also going to see the shrinking space of that distinguishes or creates a dichotomy between our legal traditions and the civil law. Of course, there are very many similarities. I think the one example that I have seen that has come very clearly is, I think, the good faith principle. For civil jurisdictions, you tend to imply it into contracts, and with the common law, we tend to say disclose whatever requires to be done between the parties. If you look at the FIDIC suite of contracts, in their golden principles, they've adopted that whole principle of good faith, and you can see that it is becoming more mainstream. And because of the way we see the trajectory into dispute resolution, alternative dispute resolution, then we can expect that the lawyers, me being one of them, also should familiarize themselves with what is not only happening. If you're in a common law jurisdiction, you should know what is happening there. If you're in a civil law jurisdiction, also understand the general principle and see where they meet, where there are slight nuances or distinctions, because this will tend to affect the way that we are resolving our disputes. Another example, and I know there are very many, but questions of legal privilege and discovery are also issues that we can expect will be different, or the perspectives will be different if you're an arbitrator sitting with parties from the two different key legal traditions. So we are looking at a change, a wholesome change in how we look at where we are coming from, where we are, and where we are going. So, of course, then my main point then is that we need to adapt. We need to look at the challenges, and look at the challenges not as obstacles, but opportunities for, evolving our legal tradition, evolving the way we manage international arbitrations, and also where the challenges lie, all the way from the beginning of the process of appointing a neutral, how they take up the matter, whether it is administered, whether it is ad hoc, and the output, because we're all looking at an enforceable award and looking for a jurisdiction where we will be able to enforce. Now, we've written, and I think my vice chair is here, Dr. Kenneth Wayne Mutuma. We've written a book on Africanization of international arbitration. So another new emerging issue or trend that affects not only Kenyans, but all of us wholesomely, is that there's the current drive. There's a current push. There's a current, and I think it's very intentional to ensure that arbitrators of African origin or descent have a footprint on the international arbitration platform. I know we keep on saying that we want to see a few more names, a few more personalities, but truly speaking, because a good number of particularly ISDS disputes, they involve Africans, and who better to understand the African problems than somebody who has grown up on the continent, who has roots in this continent. So, of course, we know the challenges that we have faced, and we know that we still have to make our presence known. It's still a club, but we also need to push our way to ensure that that club also includes us as African arbitrators. And not to oust, I think that's the only word I can use, not to oust the prevailing or the current arbitrators, but to look at the expanding scope of arbitration, international arbitration, ISDS, the expanding scope with technology, with ESG, and to look at ways we can collaborate on a global scale, because that is the real opportunity for each and every one of us. We come with rich backgrounds. I think Clive was saying that we are presenting before, is it a combined age of 150 years of senior counsel? That is real experience. And if you combine everybody else's experience and age in this room, then we have a lot to offer. Not only the global south, the global north, we're looking at the entire world. They need our views as well. So our voice needs to be done. So of course, capacity building is key. Training, as CIAB chair, my first go-to is always, let us train. Let us get the post-nominals. Let's get the fellowship. Let's get the chartered arbitrator. Let's also look at all the other skills that we can get. I'm also trained, like you mentioned, at King's College with FIDIC on construction adjudication. I'm an advanced adjudicator. And I know that also the nuances in construction adjudication, they differ from what we are familiar with in arbitration. Mediation also provides its own unique dynamics, and there are very many ways in which you can collaborate in building the capacity of all. Now, the average age of arbitrators is about 60 years. If we take all the arbitrators around the world, that's the age group, the median. So I think it's important to look at mentorship, because if the average age of many of our African countries is 18, 19, we have to handhold and bring up a new generation of professionals who will be able to take over the mantle and build the space. They'll also, because what we've seen in Kenya, we embraced not only arbitration, but mediation. And in the beginning, we thought when mediation comes, quarter next mediation, it's going to kill arbitration. Actually, the converse is true, because everybody now feels that ADR is the way to go. They're looking at ADR as, okay, I need to think about the multi-door. When I'm walking into a dispute and resolving it, I'm thinking, my dispute will probably be well suited with construction adjudication, or this could be done through mediation or arbitration. So actually, multi-door has opened up a whole new world of opportunities. So of course, education reform to comply with the new experiences that we are having. Well, I forgot to mention, I prepared all this, the images on AI. That's Copilot on Microsoft Edge, and I had a lot of fun doing it. So this is the young generation that I'm talking about. I deliberately did this because, you know, the face of Africa is the face of everyone. I think this is a rainbow nation, and we need to embrace that and look at how to talk to how we are training the youth, how we are training the future generation, and also how we are networking, and make sure that we leave a real footprint through policy advocacy, and ensure that the way we've done something here in South Africa, in the SADC region, that can be scaled up and replicated. In the MENA region, it can be scaled and replicated. In West Africa, it can be scaled and replicated in East and Central Africa. So yes, I didn't leave out the older generation, AKA us. So the real opportunities that we as Africans have and as lawyers is that we all have diverse expertise. I talked about the different legal traditions. I'm thinking about the different legal specializations that we all possess, and that is what we need to leverage. That is where we need to bring that expertise, because if we don't do something about it, in the age of artificial intelligence and AGI, I had this term recently, if we're not careful, we are going to become a data colony, because we are not putting or inputting what is unique about Africa out there. Meanwhile, the artificial general intelligence, they're calling it an arms race. The arms race is between the global north and China, and everybody is afraid of each other. But if we don't do something about it now, our voice will get lost in the wilderness, and we will be importing data as opposed to contributing to the general legal environment, and also the cultural, the social, the environmental, etc., etc. We are culturally fluent in many of the ways of many of the peoples of the world, because we are represented here. In fact, if you go to many conferences, and I'm just looking around the room here, you find one culture is represented. But if I look here, I see all the cultures. I think that is the beauty of South Africa. That is the beauty of Africa. And we need to recognize that this is an opportunity that we can take from and put forth to the rest of the world. I firmly believe, because I've been training arbitrators for myself personally for the last 12 years, we have records for the last 40 years in Kenya. Our experts are just as good as, if not better, at resolving the world's problems. And I do believe that this is something that we must leverage and bring that voice into the complex international disputes that we have and that we are going to continue to have. I think I can stop there so that I can
Thank you
allow...
very much, Jacqueline.
Thank you, thank you.
I mean, I think that I think it's that last slide, which is still on the screen, says it all. And it's that we have the expertise in the African continent. And when you're bringing people in to sit as arbitrators from external jurisdictions who have no knowledge of what happens in Africa, don't understand that Africa is 53 different countries, that it has deep-seated history, that many people are incredibly well educated, that there's a lot of attorneys, there's a lot of lawyers within the continent who can do the job. Some of them are doing it, and I think it gives a very clear indication on Jacqueline's presentation that certainly from a Kenyan perspective, Kenya is prepared and going forward. And I think the important thing is the issues that were raised, and it was in previous seminars it was raised, or previous discussions it was raised as well, is that give African arbitrators an opportunity. So if you can't just say, well, they don't only have 2 matters that they've ever done. Well, if you never give them the opportunity or don't appoint them, they will only ever have 2 matters. And yet that skill, that expertise, and that diversity that exists is not being used and not being channeled into the arbitration forum. So thank you very much. It's a great introduction to where we're going. Veronica, you've grown up in the UK and done a lot of arbitration and international arbitrations in Africa. I think I'll ask you 2 questions. The first is, what makes a successful arbitration? And then the second question is, from a UK perspective, when you were dealing with matters in Africa, did you see challenges and were the issues that arose, or do you see Africa as ready to take on the mantle of international arbitrations? So a lot said, but I'll leave it up to you to answer. Thanks, Veronica.
Sure. Thank you. So to deal with the first part of the question about the elements of successful arbitration, a lot of these principles will be familiar to most of you, so I'll just cover them at a very high level. But the first is obviously up-to-date modern arbitration laws built on international best practice. And as we know, many African jurisdictions do have such legislation based on or adjacent to the model law. And actually, recent years have seen a flurry of activity in that respect, with a lot of countries bringing in new legislation. And the reason that that's important is it demonstrates that governments across Africa are making it a real political and economic priority to be seen to be creating arbitration-friendly jurisdictions. And that should give inspire confidence in the process, and that will also have a trickle-down effect, hopefully, on court attitudes to arbitration and users' attitudes to arbitration, especially in places where there's traditionally a bit more distrust of the process. And again, on the legislative side, I think there's perhaps a misperception that established arbitral hubs are safer or less likely to have changes in their laws than African countries, which might harm arbitration. But we know from recent years that that's not always true. Look at, for example, a few years ago, Dubai unexpectedly abolishing the DIFC LCIA arbitration center. And that is a region that does do African arbitrations, and it just goes to show that what are, I suppose, seen as safer seats are not necessarily safer than a lot of the jurisdictions we have available here. The second component for a successful arbitration is courts that are supportive of the process, that enforce arbitration agreements and awards. And again, that there is inconsistent decision-making across the continent, but that is true of all of the continents. Court delays can be an issue, but again, as we heard in some of the sessions this morning, again, there's problems like that in India and other jurisdictions. And also many countries here do have good track records of court approaches, as we've just heard. Kenya in particular has been really making a lot of positive and consistent decisions in that respect. Thirdly, arbitral centres. Africa has got a lot of arbitral centres. Some of them will have more experience and be better quality than others, but what it certainly does have is a core good group of well-established centres with international recognition. For example, AFSA has already administered disputes with parties from not only Africa, but Europe, the Middle East, North and South America, and Australia. The fourth element is the sort of practicality side. Venues that are easy to travel to, have hotels, hearing venues, availability of local legal counsel, experts and arbitrators. And as I hope we can agree this week demonstrates, that is available already in Africa. And fourthly, as a number of sessions have already touched on, enforceability is key. And there's sort of two aspects of that. The first is the proper conduct and scrutiny of the arbitration in a way that's designed to prevent a losing party from resisting enforcement on the basis of a supposed irregularity or public policy argument. And just to raise, if I dare again, the very well-known case of PNID in Nigeria, that is evidence that these sorts of enforceability issues can crop up anywhere in the world. London is seen as an arbitration hub with a prominent tribunal appointed on that case, and there were still nonetheless concerns about the conduct of that case and the consequences from an enforceability perspective. And then the second element of enforceability is being a signatory to the New York Convention is very important, and almost all African jurisdictions are. So I think what I was trying to set out there is that the elements for a successful arbitration do vary across Africa, but that's obviously to be expected, but there's certainly a number of jurisdictions that do satisfy those requirements. And also, just to emphasize, places that are seen as more established and reliable arbitration hubs aren't always necessarily. So that, I think there needs to be a changing in perception in what is seen as a trusted place to arbitrate. And for my perspectives from a UK solicitor, I think, again, we all know that a lot of African disputes go to London, and it's true that we had parties from Zambia, Nigeria, Ghana, Eritrea, and the thing they had in common was they'd all come to arbitrate in London, and so they'd chosen not only to go out of the jurisdiction of the relevant parties, but out of Africa. And so while you can understand the arguments, for example, for Zambian and Nigerian counterparties not to arbitrate in one of those countries, it's less clear-cut why they would choose to go to London rather than Johannesburg, for example. But I think recent years is showing that that is something that's starting to change. And when I started getting involved on disputes in Africa, there were new ways of doing things that I was less familiar with, in particular, developing sort of really effective, productive relationships with local council could sometimes be a little bit tricky. There was differences in cultural workplace practices, local bar rules and disclosure and privilege, your approach to client management and those sorts of things. But obviously that's true of co-counsel anywhere, and actually when I've had a co-counsel in England, I've gotten with them a lot less. So perhaps it's just a problem that's always applicable. And another thing that I saw was that I was less familiar with was seeking to utilize courts if you were in a jurisdiction that was more hostile or suspicious to arbitration as a delaying tactic, so applying for spurious injunctions and just things like that to slow the arbitration down. And I think a final element that was my perception when I first started getting involved in African arbitrations was it was a bit of the unknown. So you can go on AFSA's website and you can read all their really great publications and you can read their rules and see that they're up to date. And same for, looking at court decisions to check how arbitration friendly you think a jurisdiction is. But it can be, you're sometimes looking at information in the abstract if you don't have much first-hand experience. So, for example, in London, the LCIA every year publishes an annual casework report, which is a really detailed set of statistics about things like how many challenges there have been made to arbitrators, what percentage was successful, how many times people applied for interim relief, how many times it was granted. And the English Commercial Court does a similar annual report with details of arbitration-related legislation, so you can see how often challenges and appeals are successful and that sort of information. And what I've found so far, although if anyone would like to point me in the relevant direction, I'd be very grateful, is that sort of information in some jurisdictions is not always as readily available. So you're more reliant on sort of working with really closely with your local partners who've got a much deeper understanding of those sorts of things and seeking out publicized judgments in that respect. And so, yeah, since I've been involved more in arbitration in Africa, I am getting a better understanding of ways around some of those just differences between my previous work in London and how things are done here, and particularly just getting up to speed with the real breadth of technical knowledge on the continent, not only from lawyers, but also a lot of experts and academics that are active and that we've instructed in our cases. And so I think it's clear that the elements to a successful arbitration that I spoke about previously are available in some, not all yet, but a lot of African jurisdictions.
Great, thank you very much. And I think it leads in a lot of this automatic referral back when contracts are drafted to say that the seat will be London, the seat will be Paris, the seat will be Geneva. To get into a habit as practitioners in Africa where you may have somebody in Zambia or Nigeria, what is wrong with making sure that arbitration remains on the African continent? And whether it's in Nairobi, whether it's in Johannesburg, whether it's in Cairo, which are the three of the biggest arbitration centers in Africa, what's wrong with that? What's wrong with that situation that you're keeping it in Africa and you're making sure that it's been dealt with in Africa by people who are able to deal with it and understand the culture and understand the particular countries from which those individuals and those litigating parties originate from? And I think that, Kaya, that sort of leads into asking a few questions of you. And when you, in particular in the SADC region, which you practice in international arbitrations within the SADC region, and how have you felt that whether we're ready and prepared as within the SADC region specifically for international arbitrations and the evolution of that into making sure that those are retained within the region?
Thank you, Clive. I think the very short answer to your question is, I think we can only safely say that many of our fellow practitioners are in fact ready. I think if one has regard to the number of people in this room, the number of arbitrators who are of African descent who are before us, I think that answers the question swiftly. We've noticed that in some of the contracts that we're preparing quite a lot, and some of the contracts that may have been prepared by other practitioners that come before us, that we find that we are definitely arbitrating within the continent and specifically within the SADC region. I think there's still very much a drive that does need to happen where, if work is being done in Kenya, then the arbitration should be in Kenya. But I think that's, as long as the work is remaining in Africa, in my view, I think we're doing well in that regard. I think I think about 5-6 years ago, I worked on an arbitration in Zambia where the work was being done in Zambia, but the seat was actually Johannesburg. I think the reasons for that vary, and I think they are potentially known to many in this room. I think sometimes there's still a perception of whether or not there's safety concerns sometimes, that kind of stuff. But I think generally speaking, I think as African lawyers, I think we can safely say that we are comfortable in the space that we are in. We're familiar with our contracts, we're familiar with the rules that apply to our arbitrations, and I think we've done very well to ensure that, I think over the years, I can't remember the last time I came across a UK-based arbitrator arbitrating on the continent. And I think that for me is a very good sign as to the direction in which we're taking, and I think it's a very positive sign. I think yesterday we saw the signing of the charter, And I think what that charter, to me at least, represents is an acknowledgement by African practitioners as to where we are as arbitrators and then people involved in arbitration on the continent. But importantly, it's also an indication that we are committed into moving in a direction that seeks to ensure that African arbitrations remain in Africa and in fact are decided by Africans. I think the whole day yesterday and a bit of today as well, I think there were some very impressive numbers that were discussed about what EFSA has been able to achieve as a body in relation to arbitrations in Africa. I think that it's one decision that has been challenged successfully in excess of 140. So I think that's a very impressive number. I think earlier we were speaking to one of our colleagues from Botswana who mentioned that, EFSA's opening an office in Gaborone. And I think that in of itself is also a very good sign and an indication as to where the arbitrations in Africa are going. But it also is a testament to our readiness to continue to arbitrate in Africa, as opposed to taking our arbitrations abroad, alternatively bringing in internationally qualified lawyers to run arbitrations in our country, in our continent.
Thanks, Kai. I mean, are there any particular hurdles that you still see for us to overcome? I know Jacqueline's mentioned some of them. In your experience, are there any hurdles that you think we need to highlight and be working on to overcome?
I think, like most lawyers, I think sometimes when you're faced with a question, you tend to defer to what judges tend to say. I think where Judge Masuneke yesterday mentioned that, there's this arbitration ecosystem and there's various role players, from government policymakers to the courts, to the attorneys, to the clients, which is business. And, you mentioned that the need for learning, mentorship, within that space to ensure that each role player plays their roles, but is in fact trained and mentored throughout the process to ensure that arbitrations that are taking place on the continent, and specifically within the SADC region, are in fact being conducted at the highest level and not just as a courtesy.
Great. No, thanks, Guy. Thank you. Then to get away from the strict arbitration and more into the technology side, Kim is here from and going to take us through her views as an associate director in control risks. And the question I'd like to hear from you is this arbitration from a technical perspective. I know that's very wide, but let's start there as to where is technology going? How is it assisting the arbitration process? And is it something that's real, or is it something that's people pay and say, yes, no, it is happening, but it's not really? What is your experience so far in assisting in the arbitration process?
So my experience is we're ready. We're there. The easiest part is technology can be rolled out anywhere. There's no jurisdictional limits. There's no complications. I think our biggest limits would be electricity and Wi-Fi connectivity. So the COVID pandemic drove digitalization by necessity. And I think the rest of the world sort of gradually upgraded. In Africa, we had this push, and it created this hunger to be ready, to be on par with everyone else. And it forced us to perhaps get to the same end goal as the rest of the world a little bit faster than they had. We're definitely not behind when it comes to technology. If I take to do a forensic imaging, during the pandemic, we realized that we can perfectly easily collect images outside of our region without traveling. We can have an image done of someone's mobile phone, someone's laptop, someone's email data in South Sudan while sitting in Johannesburg. There's no reason why we had to travel, which has perhaps given us this confidence that if it's so easy, what's stopping us from embracing technology a bit more? The utilization of technology in arbitration, I think the perception was that it's a nice to have. It's sort of, we like to use it, but we don't have to. We can get through the data easily without using it. My first ever arbitration matter was a construction matter many, many moons ago. And we had 300 files. couple of boxes, few paralegals going through the documents. It was really simple and straightforward. The data, or the boxes, or the files, should I say, were selected by the client as what they perceived or thought was relevant, which immediately puts that restriction on you. Is this everything? Have I got everything I need? Currently, we have a case where we started doing our data mapping late last year, and we got to a point where we reached 50 terabytes of data. There is no ways you can get through 50 terabytes of data in a short period of time. So we had to look at technology, and we had to look at how can we bring this down to a manageable size, but also keep in mind that you don't have the open checkbook attitude in arbitration as you would in litigation. So you can't just throw money at the problem. You can't throw people and technology or go and invent something to get through the 50 terabytes of data. So we had to look at it, and we had to think, what is the best way to get through this? And I think our best approach was the fact that we planned. We didn't just go in steamrolling across the data and collected everything. We looked at our data, we looked at the custodians, we looked at the date periods, and we planned it to the T. We brought our 50 terabytes down to about 20 terabytes, which fell within the custodians that we were interested in, as well as the date period that we were interested in. So again, 20 terabytes. I can't even tell you how many documents that would be. So we then had to move on to the next step. Now, I should point out, at this stage, the lawyers were not reviewing documents. We were literally just looking at our data universe. We were literally looking at what types of data do we have, what is going to be disclosed at the end of the day. The 20 terabytes came down to about just over 10 terabytes of data, which was about 12 million documents. Now again, to review 12 million documents is ridiculous. We can throw rooms full of paralegals. I should add, this is across jurisdictions. There's language barriers, so if you are going to review 12 million documents, you need to have multiple language skills. You need to have a lot of people in different regions working 24 hours to get through this data. So by using technology-assisted review and AI, we managed to bring the 12 million documents down to a data universe of about 900,000. Which makes a bit more sense. And in that 6 months, we've gone through our 900,000 documents, and we are disclosing 300 out of all of that. And the 300 is what our experts and our lawyers are looking at. Everything else was still done with the guidance of the lawyers. We didn't just go randomly selecting documents, but they did not have to sit and go through a lot of duplicates or unnecessary chains of emails where you have 20 custodians and you have to read the same email 20 times. We made sure that the documents that they looked at was the most responsive in that data set. And I think the importance there is data is growing exponentially. I had a slide with some really random figures, and we can't keep up with how data is growing. And the traditional way of doing business is also changing. I find many people now use WhatsApp. Many people use chat platforms. It's becoming more important or a focus area where we're less worried about emails and we're actually looking at everything else going on around us. And we need to find platforms that can accommodate the different types of data and the different ways in working. Which brings me to the right tool for the job. If you look at e-review platforms, they all pretty much tick the box of doing the same thing. They're all going to get you to your end point, but they have certain strengths. So if you have a arbitration matter with a huge universe of data, you'd probably want to embrace artificial intelligence. You'd want to embrace technology review or technology-assisted review, because it's going to simplify your actual time that you spent on documents. If I had to look at what limitations there are, I'd say it's probably people. We have this fear of AI. We have this fear of using technology-assisted review. And that's probably where we need to change the mindset. I think many people are very eager to embrace AI, But then when you think about it, you think, well, do I really want to use it on this big arbitration matter? And in all honesty, if it's used correctly, the right tool for the right job, you could really make your life easier. And it goes back to that working smarter, not harder aspect, is let's just plan. I also find that with arbitration, what we need to focus on is, before we even get to the point of having that initial conference, we should know our data universe. We should know where's the data. Is it in the cloud? Traditionally, arbitrators would not consider cloud storage. It was seen as excessive and unnecessary. But now almost everything is stored in the cloud. Can you comfortably say, we're not going to collect data from the cloud, we're just going to take someone's mailbox from the local server? So I think it's that planning stage that's going to save you time and money and effort in getting to your endpoint. But with regards to, are we ready in Africa, we're most definitely ready.
Good. Thank you very much. And again, I think it's part of it is a mindset. I can use a personal example. I had a matter in Australia where we were dumped with 1 million documents, and we did a quote for the client and say, well, that would X number of people per day reading documents is what it's going to cost. And a company came and said, we run algorithms on these documents for you. And we said, okay. And they ran the algorithms, and we ended up in a situation that we had plus minus 100,000 documents. And then we got that down, and the bundle at the end of the day was minuscule compared to what had originally been dumped on us. If we hadn't had that algorithm, we hadn't run that computer process, we'd have still been arbitrating today. But you have to accept that we mentioned earlier on the average age of arbitrators and getting used to this. I missed out on AI and a whole lot of other things during the course of my career. So I sat initially when we looked and said, I'm not sure that I trust this process. What happens if there's a document I don't see? And I was assured that the way the technology works, you're going to get the comfort that it's been done, and you're going to end up with what's really relevant. And I think that's the challenge as well. I think it's the challenge for all of us. It's a mindset as we evolve in international arbitrations. There's members sitting in here today who are very experienced in international arbitration. But as we evolve, and something that Jacqueline raised, which is so important, you've got a population that are average age of 19 in Africa. Now, you've got to be bringing those 19-year-olds through to become lawyers, to become experts, to become eventually arbitrators, train them to be the best they can, and you're going to have a populace of arbitrators coming out of Africa going to Europe, going to other jurisdictions and being put on panels to say, we're just as good. And I think that's the aim. That's where we have to keep moving towards. Have we solved all the problems? No, far from it. Are there some jurisdictions that you'll still have a great deal of difficulty in arbitrating in? Yes, there are. But as you see, as we move forward, there's less and less countries where that is a problem. And more countries that you can have an arbitration dealt with as effectively as if you were sitting in one of the European jurisdictions. And that's what we've got to aim for. We've got a bit of time, and so I think let's open it up for some questions. It's always good to hear from the audience, and if there's any issues you'd like to raise. So please, over to you, and any of our panelists are more than happy to answer any questions. All quiet on a... Great. Okay. Jacqueline, you wanted the last word.
Okay, thank you for the Okay, yes, thank you, Clive, for the opportunity to say a last word. I think where we stand today, nobody can say with any reasonable assurance that we know what tomorrow is going to hold. And notwithstanding the fact that, like I said, our average age is 60, I think it behoves us to either get that knowledge or, because we can, look for the younger generation to help us in the spaces where they are better equipped. And that's how we're going to be able to solve the problems that we have, the new developments, the evolution of technology, how it's being used. Like Kimlin said, we are finding different people are using different technology in a different way. So my thinking, I think my challenge is let's keep on training. That is CIAB's forte. Let's keep on building our capacity, and let's make sure that even those around us are also acquiring this necessary training. We have academics amongst us. Let's also delve into the new issues that are emerging. Yes, let's by all means use the apps that are coming in, but let's also find out what is the legal implication, because with AI, we have the black boxes and we don't really know what's happening inside of that black box. Is there a legal implication? We may want to just look into that and make sure that we have the answers before, we need to respond to the questions that are going to emerge. Otherwise, like the Chinese said, I think it's a Chinese curse, not sort of blessing. May you live in interesting times. So I wanted to, I think there's a question?
Yes, please.
Comment.
So I can speak from our experience that we will not use AI that's open resource AI. So any AI that we've used is developed, and we can vouch for that data protection and jurisdiction. So it's still a very gray area in that how far are we going to allow development to make sure that we keep that jurisdiction or that control over the data, and how much are we going to embrace it and go, well, everyone else is using it, let's do it. So it's still, from our point of view, we still restrict it to, it's not open source, it's not ever going, well, I can't say ever, it's not going to leave the confines of our own security, which we can vouch for. But I think it's one of those legal questions we will get to at some point, because specifically in South Africa, and I know some other African regions, individuals are starting to ask about their data protection and what are you doing with my data? I think if you look at the UK, for example, I see how many projects we have in the UK for data subject access requests. It's frightening, and I've not seen a single one in Africa. I've not seen anyone actually go, well, please prove to me that my data has never left. So I think we're going to get there. But for now, as Jacqueline has said, is to ensure that you understand where your data sits and you understand the basic principles of the AI that you're using. And the questions that you ask at your pre-trial or your pre-arbitration conference is, what is the algorithms behind the AI, how is it shared, and how is it controlled and protected?
Whether it's preferable to have an AI who would give you a 5-minute quick answer to your arbitration, but then it's on a standard platform and an accessible platform, and you don't know where the data has been protected in a private dispute resolution process.
Mm. So I think, again, it's the right tool for the right job. So we found that we've not used AI to give us the answers. We've used AI to take the answers that we've already identified and put it into a sensible manner. So where we've used AI or generative AI was to take all of our findings, all of our relevant documents, and to actually give us a sort of case map of what happened in the last X amount of years or during the process. So it's how you use that hammer to get to the end point. It's a very reserved and maybe careful way of using AI at the moment. working for a risk consultancy, that's what we do. We mitigate risks. I think there are going to be instances where people will probably be a bit more cowboy about it. But again, it's how you use it and what your end result is. What do you want it to do? We don't want AI to make a legal judgment or a legal call for us. We want AI to make our life easier by taking the work that we've already done and structuring it into a way that we can present it at arbitration.
Thank you.
Thank you very much. Yes, another question in the front.
Thanks. I have a question for Jacqueline. It may be quite a philosophical question, but it seems to me that there's a bit of a tension between, on the one hand, wanting all these AI models and large language models and so on to be trained in a way that incorporates data from all over the world and not just North America, China, and to some extent Europe, right? Versus also protecting intellectual property and protecting innovative ideas. So I'm reading and seeing quite a lot of pushback from particularly authors and artists and content creators to say, why are these models incorporating all my data and using it, you know? But if we don't participate as Africans in that process to some extent, we're going to end up with arguably lopsided models, right? So how do you resolve that tension?
I think time will tell. But also for all of us, I think there are ways of protecting your data. There is some intellectual property that belongs to all of us and belongs to the whole world. You know, the folk tales and the folk stories and many things that are, like would say, inherently African. If we don't put it out there, then unfortunately what is going to happen is that we will adopt wholesale Western culture and we will not have a say. And our culture is not really just about maybe the clothing, the designs. It's language. We have 7,000 languages on this continent. So the way we speak it, the way we use our idioms, that must be put out there so that we have a repository so that the future generations will know that this is what Africa was, this is what Africa is, this is where we came from, and this is where we are going. The other thing we need to also remember, quite a number of our material is getting out there through the social platforms because the age of the demographics currently, we also have a very young population, very low at the base of the pyramid. But what is being lost in the translation is that it's mixed up with so many other things. So we do need to make a concerted effort to also contribute to what is being put out there. There's data scraping, of course that has happened, that ship has sailed, but we also do need to make sure that as Africa, we are collecting our own data and we are also incorporating it in the things that we do, the things that we say, the things that we write, and everything that we are communicating amongst ourselves, that is intra-Africa, and also out there. Now, for us to say that I as an individual will do my part, that is step number one. It is not sufficient. Maybe us as the whole of the African continent, that is something that we can do as academics, as practitioners, and even as lawyers. Because if we don't put, for instance, our culture into the legal process, it is going to be lost forever. Yes. So, Clive, you will allow me?
Yes, sure.
I don't know whether there are other questions, but I wanted to say thank you to CDH and Clive and my fellow panelists from the Chartered Institute of Arbitrators. I am going to give them some bags. I know Jackwell knows we do this a lot. It's African culture to not go empty-handed anywhere. And thank you so much for your hospitality and including CIAB Kenya in the AFSA conference. I have included 2 sets of our journal. CIAB does publish the ADR journal. This is issue number 2 of 2024. So please put it in your libraries and make sure that you share it amongst your communities. This journal is available online for free on our website. So that is us contributing to the African discourse. So allow me to make the presentations and then also invite you to our conference, which we are holding on the 15th to the 17th of May, 2024 in Nairobi. And one of the new developments that have happened that are great and I think good for arbitration tourism or tourism is that the borders are collapsing and you don't need a visa to come to Nairobi. So you're most welcome. Thank you.
Thank you. Thanks. That's really kind. Thank you. Oh. Put this in front. Great. Thank you very much, everybody, and thanks for coming and listening. Thank you. Thank you, panelists.
we're going to discuss the topic, and I think it's the probably the only one yesterday, today, and tomorrow where the panel is not all lawyers. So the topic really turns around the question whether chartered accountants or then professional accountants are experts. Are they experts in disputes, or should they be arbitrators? I thought it would be, for these purposes, good to actually have a panel of professional accountants as opposed to lawyers. I think I'm one, and that's enough for this panel. We're going to run the session. Our panelists will each have a few minutes to make some remarks about how they see the question, and then we will ask some questions, and we'll also open the floor for some questions. I think there might well be a few questions to our panel. So to our panel, I am privileged to know each one of them. To my left is Louise Jordan. Louise is a partner at Stone-Turn. May I say a chartered accountant and a seasoned professional in the disputes world of many years standing. And she's also a panelist on the experts panel or the accounting panel at EFSA. To her left is Susanne Breitenbach. Susanne is a partner at Ernst & Young, EY, in charge of running, well, I think you have a few hats. For this purpose, I think the important one is being responsible for the dispute resolution business in EY. Also a chartered accountant and a disputes professional of many years standing with a high reputation. Susanne is also a member of the accounting panel of experts at EFSA. And then to the far right, a dear colleague, Hans Biltu. Hans is a partner in our Mauritius practice. He's heading up advisory. Hans has traveled in his life, in his professional life, from the UK, where he was educated. He worked there. He worked in France, and then returned to, may I say, the beloved Mauritius. I see no reason why one would not want to return there. Hans has got quite a bit of a significant experience in regulatory disputes and valuations. So, without further ado, and I need to recognize the previous panel in Breakout 3. It was quite a distinguished panel with Azar Bam, SC, Prof. Butler, and the Free Hills team talking about experts and the needs of experts. So we all listened, and we're up to scratch as to what it should look like. But this panel, we talk about CAs and what their prospects are in terms of the arbitration world and the disputes world. So I want to start with Hans. I think your opening remarks are going to trend along the line of the qualities of chartered accountants and professional accountants and how that could be appropriate towards these roles. So please.
Yes, so thank you, Dian, and good afternoon, everyone. So looking at the topic when I was preparing for it, and based on my experience, first of all, I knew that I would be speaking to a number of lawyers, and the relationship between a chartered accountant and a lawyer in a professional capacity goes a long way and goes in various sectors, and also and in particular in a dispute resolution environment when it comes to commercial disputes. Now, I was in the previous session where we were talking about the qualities of an expert and how to make sure that we get a very good expert. Or one thing which came up and which I've also noticed is there has to be a very good understanding between the lawyer and the chartered accountant, and the chartered accountant has to understand what the lawyer does, and the lawyer or the parties appointing the chartered accountant should also have a very clear understanding where the chartered accountant is coming from, what the chartered accountant can deliver on, and what the chartered accountant can deliver on that would be admissible and defendable for the purpose of the process, and where the tribunal will be getting value. So I would start by saying, by presenting to you a few things from my perspective where it is actually important to know how the expertise you are looking for when you approach a chartered accountant has been designed by training, designed by standards. So at the very outset, a chartered accountant is trained on a number of financial techniques, the most prominent one being auditing. However, when you look at most chartered accountants, and if you look at the chartered accountancy world in general, what you see is most of the fees generated by the chartered accountant or qualified accountants community is actually non-audit. And that says a lot about the application of how that expertise is designed. You know, how is that design being put into application? Now, at the very outset, by default, a chartered accountant comes with an expertise that allow that person to deal with financial and economic subject matters. See, the chartered accountant is trained to deal with a number of, to deal with information, recording that information, controlling that information, and reporting that information for the purpose of advising, planning, auditing, conducting due diligence, valuing transactions for regulatory purposes. So the first aspect of design of that expertise is multidisciplinary and by default an expert in financial and economic subject matters. Now, this is where, based on experience, when I have worked with a lot of lawyers, I have seen in many cases where under pressure or through excitement, you see certain chartered accountants in a case environment venturing to talk about non-financial or non-economic matters that is outside of the standards they have been trained under, bearing in mind that those standards are recognized as a reliable. So this is the first conclusion. Now, in terms of the application of that expertise, I see value as a chartered accountant when a lawyer or someone appointing me would ask me, by the way, you know, what is your field of expertise? And you would be, I'm certain, you ask that same question to a number of chartered accountants with the same background, coming from the same geography, you will get different answers. First of all, there is what I call the second nature. An accountant is trained to write reports, write opinions, work under a contract, an engagement letter. They've got a scope of work, and they are designed by that form. But is that what you're looking for? Does the accountant have to stretch outside of that environment for the purpose of your needs? And you will see, if you go and you ask a chartered accountant, well, what's your area of practice? Some of them would say the sector they serve, so they would say they are a sector specialist in oil and gas. You know, they've audited, they've done valuations, they've done reviews, they've done deals. Some of them would say an area. Some would say accounting, auditing, valuations, pensions, investigating frauds. Some would say skills. They'd say, you know what, I'm specialized in data analysis. But data analysis for which sector? Data analysis for which type of institution? Data analysis for which purpose? And then you've got the other form of specialism, and you do get that as answers as well when you ask, and that comes more from experienced, what we call the trendsetters in the profession. Some chartered accountants are known to be able to influence those setting the standards. They form part of consultation panels which would allow the regulators to set the standards. Your potential clients or parties have to account or report. So I think the message here is, I think it is very important to understand how the knowledge of the chartered accountant you're approaching is designed, how that knowledge has been applied, how that expertise has been applied, and most importantly, understand from the chartered accountant how they will basically be fit for purpose for the process you're looking, the legal process you're looking at. And are you looking for a sector specialist? Are you looking for an area specialist? Are you looking for a particular skills? Or are you looking for someone which would understand the professional standards? Now that would vary case by case. Coming to the topic we're discussing, I will give you my views now on how I feel a chartered accountant goes from being a chartered accountant to an expert in a dispute. What more is needed? First of all, a chartered accountant in the legal process has to be more than a normal chartered accountant that would just be writing an audit report. They will have to go beyond a prescriptive approach, and has to be able to understand the context in which they're working, understand clearly the instructions from the lawyers, be very articulate. Very often I've been in cases where the tribunal stopped and asked the lawyers to speak to the chartered accountants to say, they want a conclusion, they don't want a lecture, they don't want jargon, they want layman's term. So this is, there is some expertise to be had there. However, on a more reassuring note, I will give you an example where I feel why a chartered accountant will be a good expert in conflict resolution or as part of a dispute setup. You see, at the very base of what a chartered accountant does, we are trained to ensure that what we treat, what we use as information, satisfies certain criteria of integrity. Okay, and this, I know it by heart because every information we get, or I would normally ask 6 or 7 questions. Is that information properly presented? Does that information, or is that event for which I've received that information, does it exist? The one that is providing that information, do they have a right to it, or that company has a right to have that obligation, or has a right to that information, or a right to that benefit so that they can recognize it? Do they have an obligation with those rights so that they have to account for it as an expense or a payable? Is the information properly measuring what I want to look at or to analyze? Is that information complete? If it's a daily, an information that is produced daily, I'm looking for a year. Do I have for 365 days in the year? Has it occurred? Because you do have information, you do have financial information with things, showing things which have happened, but has it happened? And lastly, is it reflecting the value I'm treating? So, we call it audit trail in our profession, but the answers to those 7 principles or 7 lenses or 7 filters will then be supported. And these supports, what we call audit trail, you call it exhibits. So I think there is, in terms of data integrity, I think the chartered accountant's approach certainly meets the legal approach in terms of defending. The chartered accountant as well has a factual approach, and I think it should be clear when a chartered accountant goes into a dispute environment that they treat with facts and they should not be judgmental. And again, I've worked with in a number of cases where one of the things in preparation to the case, whatever I write, from the title to the boilerplate disclaimer on the last page, is read carefully, because at no point I should be seen to be judgmental. So what I would say is the result of what I've said is there's a fit with the skills of a chartered accountant and the need of a legal process, if there's a financial dispute, of course. Now, my key message is when a lawyer is dealing with a chartered accountant and takes the chartered accountant from his environment to a dispute environment, I do believe that it's critical that you approach the specialist as opposed to the generalist. I mean, you do, as I've said, if someone say, they've got analytical skills, they probably would have been doing a bit of everything, a bit in every sector, a lot of analysis, but a lot of sectors. Whereas, if you're looking for a specialist in the sector you are assisting in terms of dispute, the specialist would have done a lot of one thing, and they will be more confident, they'll be more articulate, they will be able to say no, if they can't do something. And the specialist, as much as the sector or the field of expertise is defined, the inputs today change. Today you've got big data, you've got unstructured data from the web, you've got filings which are in different languages, at times have to be translated. So you would expect your specialist, you would expect the chartered accountant to also have access to multidisciplinary teams. And furthermore, you would also, I believe that chartered accountants should also know the topical issues. And I will name a few. Based on my experience looking at regulatory issues, I mean, very often I'm called by the regulator to say, we will be enforcing, and you have to work with our lawyers. And then you end up learning about the different sectors and what's driving the point being in dispute. And I will give you a few examples. And this is where it's important that I'm trying to make a point where it's important that the chartered accountant you use is on top of the topical issues in various sectors. Startups, I mean, Mauritius is an investment route into Africa. We have an investment platform. There's a lot of investor activity. And I have seen, in my experience, a lot of disputes on startup investments. So there is a tendency for the new pharmacy entrepreneurs to present a valuation that is relied upon by investors, commitments are taken, and later on to see that there has been an approach where in the valuation, the promoter, there's a saying, fake it until you make it syndrome. So, you just push the numbers, it looks credible, it's relied upon, and then down the line, you've got licensing, regulatory issues, investor not getting returns. Banking failures, if you are assisting in a banking failure, whether for the clients or the regulator, collective actions, the chartered accountant has to understand back office governance in banks. Cross-border lending issues, crypto, virtual asset. there is also what we're seeing is most of the issues are because the crypto and the virtual asset world, when they raise funding, and there's a saying again between inverted commas, they prey on the misunderstanding of the investor community and the user base. So you need a chartered accountant that would be able to articulate all that in your process so that as a lawyer, you can decide, the angle you want to take, and of course, you put it in your legal process. The last thing which I feel is important as a chartered accountant in a dispute environment is also to be ready to work not only with the lawyers when it's too late, when there's an issue, but working on what I call the preventive assistance. When commercial clauses are being drafted, definitions are being put in documents, earn-out formulas are being defined, so the chartered accountant should be able to come at that stage as well, to define things which, if clawback happens after 3 or 4 years, then at least there's a proper base that has been set up. The formula can be interrogated in an objective manner and under specific standards. And I would probably stop here. And also as a CA, I have assisted many lawyers, but I will be very honest, I have said no more times than I have said yes. Because lawyers would come to me to say, we want to do this. And I will tell them, you know what, if you want me to do this, I will not be able to do this. But the few and selective cases I've taken, I've done it well. And so a quality of a chartered accountant in the dispute environment is also to be able to say no. Right? Otherwise, you would mislead counsel. So to finish, as the topic said, can a CA be an arbitrator? I've got my views on it, and I do feel that a CA is stronger or will be strongest as a CA. Can there be an arbitrator? My view is, I've got mixed views on this. I do believe that CAs are trained to value, to be objective. We apply principles. We have to support our work. To be an arbitrator require other sets of skills. I'm not saying we cannot acquire as CAs those skills, but I think it will have to come with a lot of training and experience. We CAs are not trained to interpret law or make legal determination. We will be comfortable if the arbitration is very specific, where the determination is very prescriptive and of a financially technical nature. But that said, if you ask me whether I want to be an arbitrator, I would say yes, but as an arbitrator, I would also have a lawyer or someone with legal background acting jointly with myself. So yeah, Diane, these are my remarks, general remarks, so that you understand how I sometimes think in very strange and mysterious ways.
Yeah.
Thank you.
Thank you so much. So I think, Louise, given that I think you're trending more towards a more practical approach and also looking at external factors that would impact, how do you actually move as a CA into the environment of expert evidence and whatever your view might be around sitting as an arbitrator.
Well, thank you, Dion. I think Hans has eloquently explained to us what a CA is, what a CA can do, what the technical training and experience is, and also I think how that is emphasized by the work we do on a daily basis. I think I feel a bit more optimistic about the chartered accountant being able to also act as an arbitrator, but I'm also willing to debate that and explore that a bit more. But if we then do accept that a chartered accountant can be an arbitrator, what would that practically mean in terms of getting a chartered accountant appointed? I think over the last few days we've heard in numerous instances that an arbitration clause or a dispute resolution clause is included in agreements from inception of a contract between parties, and that happens internationally and locally. I always believe that practice in South Africa got a lot of momentum when the King 4 report was published, and specifically because that requested a dispute resolution clause to be inserted in agreements in order to manage overall stakeholder relationship between the parties. But the King report required a dispute resolution mechanism. I think what in practice happened is that this resolution mechanism sounds as follows. There will be a discussion between the parties. If they don't agree, they will do a mediation. If that doesn't result in a successful outcome, then we will go for arbitration. There's one aspect around dispute resolution that I do not think has received any momentum, and that is possibly expert determination. I think the effect of that is therefore that us as chartered accountants at the moment have one dominant role to play, and that is as a party-appointed expert or as an independent expert. Now, sitting in the panel just a bit earlier, I don't think the independent expert was discussed in significant detail, and I think that sounds to me like a whole other topic for debate. But I do believe that we as chartered accountants have an important role to play where disputes are of a financial nature. And as a chartered accountant and practitioner, I've always been wondering, why do dispute resolution clauses favor mediation and arbitration? And I've always been wondering whether it is not because those dispute resolution mechanisms favor the legal profession, in that they all require legal involvement and there's a legislative environment in which that happens. So obviously, if we are talking about chartered accountants becoming involved in arbitrations, the arbitration clause will have to be key in having that happen. The arbitrator cannot exceed the ambit of its appointment in terms of the arbitration clause. So the challenge therefore comes that if the arbitration clause does not foresee a person with accounting skills and knowledge being appointed as the arbitrator, that will probably not happen. I think in South Africa, one of the most common clauses I've come across is actually the one where it says that the arbitrator will be appointed by the Arbitration Foundation of South Africa. And I have to say, I think there are very few, if any, chartered accountants on that arbitration panel. And I think this concept also applies to any other expert in this field of disputes, and could that be engineers or any other typical experts that could be required. Therefore, I believe that the arbitration clause generally exceeds chartered accountants. And for a moment, I want to set aside my views on whether we should be attending the arbitration training and mediation training to make sure that we have the appropriate training to take on those appointments. I do foresee a scenario where in a dispute, the quantum of the dispute overshadows the merit arguments and the legal arguments in the dispute. And I therefore believe that a chartered accountant with a necessary background and skill set will be an ideal arbitrator in that instance. How will that practically play out? Well, I believe it will be similar to what we are seeing at the moment. Normally in an arbitration, chartered accountants will be called as experts. So why can't a chartered accountant be the arbitrator? And if there's an aspect that has to be addressed of a legal nature, that expert lawyers get called to inform the arbitrator on how to deal with that specific point. And as I said just now, I do believe that I would like to advocate for the concept of independent experts being used more commonly than party-appointed experts, but based on the discussion earlier, that seems to be quite a topic to be debated. And I do believe that if the purpose of an arbitration is the speedy and cost-effective resolution of a dispute for your client, then surely the process must be aligned to achieve that. If we have to follow Hans's view and say that a chartered accountant should possibly not be entering the realm of an arbitrator, then I do believe that there is still an important role to play for chartered accountants in dispute resolution, and that is specifically in the realm of expert determination. I believe that is a fairly similar approach, but it's probably somewhere between a mediation and arbitration, the parties still choose the person who has to do the termination. The process is agreed contractually. There is no legal framework such as an arbitration act that will govern that process. But in other countries, there are rules and procedures that govern expert determinations. And I believe that that is an ideal process to resolve disputes regarding quantifications, valuations, earn-out clauses, and even the instance where a party just says, please can someone assist me in getting a business resolution for my dispute. I do not believe that my contractual position is supportive of the business arrangement that we've wanted to conclude. In reality, if that aspect goes to arbitration, the legal arguments carry the day and not the business arguments. Such a determination is also final and binding. The parties can be represented by attorneys. It's a very inquisitorial procedure, but legal arguments can be heard if the parties have agreed to that upfront. So I do believe there's probably, in a way, I can see your argument, Hans, but I do believe that we can be a bit braver and bolder and step up and start making our voice heard in the aspects of financial disputes. And then, as we have mentioned, I think we are today here talking about chartered accountants. And as we've referred to the arbitration clause, I think another aspect that's critically important for us to just mention today is that I generally believe there's a huge misinterpretation misconception in the legal world between what is an auditor and what is a chartered accountant. So an auditor is a chartered accountant with further training and experience, and in South Africa, they are registered with the Independent Regulatory Board of Auditors. They therefore do financial audits and express opinions on whether the financial affairs of a company, the financial statements, fairly represent the financial affairs of a company. The ambit of the chartered accountant is therefore much wider, and their ability to express opinions is also therefore broader. So I think generally, if you need an arbitrator or an expert determiner for a financial or business dispute and a specific practice area, then that is what you should be focusing on. You should only have the term auditor in any clause in your agreement if the aspect that has to be discussed or decided on relates to an audit and not a financial matter. And in that sense, I think, yes, possibly an auditor as an arbitrator is not an excellent proposition, but I do think the chartered accountant has got a good role to play and should get a bigger role to play in the arbitration world.
Thanks, Louise. Yeah, of course, we won't have a proper panel of CAs if they disagree or don't disagree with each other. But I'm sure, amongst the lawyers here, you'll find somebody to debate the point. I think there's, you did touch on it, there's a valid point to be made, especially in terms of administered or managed arbitrations. I mean, certainly in the backdrop of AFSA, the organization or AFSA provides a lot of support to arbitrators, even if and when they are lawyers. Susan, you always talk about the step up. I think you're known for saying that, when CAs want to get into the world of dispute, there's a step up to be taken. So how far does the step up need to go? And would you mind sharing your views on that with us?
Okay, so just to recap, obviously we've made the point that the exams and trainings of a CA gives them a very deep understanding of financial and business matters, but dispute resolution, when I last checked, is not part of the qualifications of a CA. And then also in my experience, what I find is CAs who have not specialized in expert witness services tend to shy away from work that takes them anywhere near a legal proceeding. So in the context of, or with reference to CAs in dispute resolution, Louise made the point that there's a difference between an auditor and a CA, and that's a very important point. And then what's also important to notice or to know is that some CAs do actually specialize in expert witness services and forensic accounting.
and they are well versed with providing support in legal proceedings. But I must say, I have not encountered many CAs who have actually taken on arbitrations. And maybe it's because the role is not well understood, and it's also perceived as the domain of lawyers. So if one were to attract more CAs to the role of arbitrator, I think the role would need to be demystified. And if it is indeed seen that it is not solely the domain of lawyers, then it needs to be promoted as such. For example, things that need to be clarified is the extent to which the procedural aspects of arbitration may be rule-based and can be learned through available training. And if legal issues arise that's outside of the comfort zone of the CA, he or she can call a lawyer as an expert. But if CAs are to step into the role of arbitrator, they would need to have a bit of a mindset change and an approach change. They would need to realize that it's no longer a case of issuing an opinion or report in the normal course for a client, but they're actually now serving a process. And they also need to consider things like admissibility of evidence, the principle of neutrality. What makes many CAs effective is their ability to respond to issues quickly, and they fall back on their knowledge of a topic. But in neutral dispute resolution, they need to be careful not to over-focus on maybe the fairness of the award, but also pay enough attention to the process they follow to get there, and to ensure that each party does have equal opportunity and fair opportunity to present their case. Then the other thing, many chartered accountants who you're not used to dispute resolution, are not used to the confrontational nature of formal dispute resolution. So they would need to have a bit of resilience and be prepared for that, to manage and navigate conflicts and confrontation. Then I also find that many chartered accountants believe even expert witness work to be higher risk than, for example, signing an audit opinion, which I find hard to believe. But they see any form of criticism or commentary or scrutiny of their work as something that's negative. And sometimes you can also find that they try and argue the client's case to the point that they compromise their own objectivity and not conceding maybe when they need to make a concession. So it's very important that chartered accountants understand when they play in the dispute resolution space that they need to understand and accept the fact that their work will be scrutinized, and it's part of a normal, robust process, and it actually serves to mitigate risk, if anything. Then there are also personal attributes that play a role. Attention to detail, the ability to distinguish subtle differences and mistakes, the ability to look at issues from multiple viewpoints and not a narrow-minded approach, to listen critically, to know when and what kind of follow-up questions to ask, and then very importantly, the ability to simplify complex financial matters in a manner that non-financial people can understand, and hand in hand with that is logical and clear report writing skills. Then if I reflect on my experience working for a large accounting firm and large accounting firms in dispute resolution, one of the benefits of involving an expert from a large accounting firm is the fact that they have access to the tools and skills of a multidisciplinary set of specialists. But although we often take on expert witness and expert determination engagements, I haven't seen large accounting firms actually running after appointments as arbitrator. And I think part of the challenge is taking a senior person out of the business who's meant to lead a team. And although leveraging a team is quite possible in expert witness, expert determination engagements, I can't see it being practical in arbitrator appointments. But then saying that, if you look at the retirement age that accounting firms impose upon their employees, which is 60 or shortly thereafter, at that point, many CAs are at the peak of their career and they still have a lot to offer in terms of experience. So maybe for those retirees who are looking for a second career, this might be, taking on the role of arbitrator might be a very attractive proposition. But just as a last point, the potential role of a CA in arbitration, I think, will largely have to depend on the matter. Maybe cases that need a very deep understanding of business or financial issues. But even in my experience, even in financial matters, legal issues also arise. And then it might well call for a blend of accounting and legal skills to adjudicate on those. Now, the question that may be asked, do you then use an arbitrator who's a lawyer who calls a CA as an expert, or do you use a CA as an arbitrator who calls a lawyer as an expert? Well, that will have to depend on the matter, I suppose, but I'm nevertheless of the view before a CA can step into the role of arbitrator, they will need extra or additional experience and qualifications. But that doesn't take away from the fact that CAs are very well suited for a wide range of financial and business related matters, and they should play that vital role of assisting in dispute resolution in that space. But whether many CAs would want to actually leave their comfort zone and step into the role of arbitrator, I think remains to be seen.
Thanks, Susanna. I think you can hang on to that. I'm going to start with you. I do want to ask our audience if they've got questions, but let me put this to you first. One question and one statement for comment. So, when I listen to it, when I look at the landscape as it stands now, my point or question, it's more confrontational question. So, do the chartered accountancy profession or professional accountants do enough to actually contribute and participate more proactively into the dispute environment? Firstly, and then secondly, it seems to me that there are, depending on the nature of the dispute, and this is probably not unique to the chartered accountancy profession, but to most professions, but depending on the nature of the dispute, the substance, the causa, or the dispute could be more closely associated with a relevant skill at a decision maker level. Do you have any view on that? And I'm posing that question to the panel as a whole as well.
Yeah, so maybe just talk about does the accountancy profession do enough? So in my experience, they've made good strides in elevating CAs into the dispute expert witness field, but elevating CAs into the role of arbitrator, in my experience, has definitely not been a focus for them. I think an important factor is obviously, there's an investment required, they need to train up people, it has a cost implication, it has a time implication. Then what's also important to note, in many large accounting firms, the part of the business that does expert witness work and forensic accounting work is relatively small in comparison to your audit practice and other consulting practice. So other business, maybe there may be other priorities that compete with the need maybe to upskill their senior partners or into or skill them to become arbitrators. But then and then there may also be a perception around risk and concerns around liability which will need to be clarified. But I think if large business maybe lobby to get more CAs into the arbitration space, then maybe that may serve as a motivator for large accounting firms.
Yeah, Hans, your take on that question?
so my take on this is, I tend to agree with Susan that chartered accountants have to do more. And it goes back to what I was saying is, the chartered accountant, the way they are trained, they are designed to act in a certain way. Now, in a dispute environment, being an arbitrator, you know, it is not a mystery that I'm trying to find some politically correct words. It's not a mystery that some may say accountants are boring. I relate it to the fact that there is a tendency for the chartered accountant, and the way the big accounting firms are designed, there's a lot of what we call management of risk. So there is a risk aversion. And coming from the perspective of a CA, getting into a legal environment means being confrontational. Getting into a legal environment means you have to be able to face the fact that you will be proved wrong. But the accountant is not designed to accept it because due process has decided that it hasn't gone their way, but due process is still a fair process, right? So I think this is where the work has to be done. And more importantly, I do believe as well that we cannot just today say CAs have to rush into stepping into the role of arbitrator or do more than what they're doing. I think the assistance that CAs are giving to tribunals as expert witnesses, as testifiers, are good enough, but it takes a personality, it takes an approach, and it is only through practice and working in that environment that I have realized that beyond the accounting standards, beyond the financial discipline, there are ways to ensure admissibility. Neutrality, for example, I'll give you an example. I have been personally confronted in a case where I was asked by the opposing party if your instructions were given in a different way, the same question put in a different way to you, would your outcome, would your conclusion have been different? So this is where you have to be mindful as how you respond, and you have to be credible. Your behavior, your contribution cannot put the case into jeopardy. And I have seen colleagues of mine, competitors, peers of mine, who, when they speak in a dispute environment, they are not properly prepared, and they would be using phrases like, I decided not to take that input. I would probably have said, the valuation standards did not allow me to take that as an input. And that, it's a sum of parts. But for the CA, I can say, it's the Murphy's rule. For me to get 80%, 90% of the CA to have that from day one will take some work. And Suzanne and Louise and Diane, we are in that environment every day. So we have to be, again, there's the language, the articulation, the confidence. This is something which a CA has to work on to step up. And also the instructions, the preparation from the lawyers are, for me, extremely, extremely important. So, Diane, I would tell you that, yes, we can step up, but we won't be able to do it on our own in the short term, unless there's a formalized, structured, and endorsed, and also approved or accredited program which would equip us. Yeah. How will that go? Is that going to trade off the time spent by counsels with us? I don't know.
Thanks, Hans. Louise, how would you respond to those two questions or points?
Well, Dan, you've known me for a long time, and I generally have the minority view in any discussion, so I'm happy to stick to that. maybe, Susan, as you've mentioned, we're all getting older, so maybe it's time now to start changing the playing field so that we can contribute to the world for a longer time. But for the moment then, let's accept the fact that even as expert witnesses, there's a lot for us to do as chartered accountants. And Dion, I don't know, can I take here the liberty of then introducing some of the assistance that the Arbitration Foundation has given us in that regard. I think many years ago, I was a representative of one of the founding members of AFSA, and Advocate Cooper then said to me while I was still a youngster, where are the young experts that are coming up in the market? Where are the younger role players that should be here? Now, it's taken a long time, and I won't call myself a youngster anymore. But the good news is, I think part of his dream has been realized. And if you now go to the Arbitration Foundation's website, you will find a new addition to that. It is called the Expert Panel. And if you click on that, you will find some CVs of chartered accountants that hopefully can assist counsel in identifying potential experts to assist in disputes. And the idea is not to stop there. So if you're sitting here and you're saying, well, I know of someone who should be on that panel, please approach us through AFSA so that we can get that person's CV so that the person can submit an application and that can be considered for the panel. Or if you're sitting here and saying, well, why am I not on that panel, or why am I not aware of that opportunity? Once again, please contact us through AFSA, and we will then send you the link so that you can apply for that. And I think maybe I should just clarify here, the us I'm referring to here are the accounting firms that are founding members of the Arbitration Foundation. We have taken this initiative on behalf of AFSA.
Thanks, Louise. I'm aware that we're eating into tea. Can I ask if there's any questions from our audience and off the floor? Leon, will you just do a run with the microphone over there? You can use this one. Sorry that we need to give you a stretch there, but...
I'm an attorney, and the thought that a chartered accountant can be an arbitrator actually had my mind spinning. I mean, because even an attorney, a dream of being an arbitrator is still, I mean, a long, long, long way. It's a really few. I mean, it's like a judge. When an arbitrator is literally a judge, and even to be considered to act as a judge, you need years of experience. Experience as a litigator, either acting for one party or the other. And that seems to be cut out from the point at which chartered accountants would be appointed. It would be an experienced chartered accountant immediately being parachuted and becoming an arbitrator. So for me, I struggle to see how that, just defining disputes or stuff like that, I'm struggling to understand how that could happen, and specifically even the approach of the few accountants and chartered accountants to issues is very, you've got your blinkers and they stay in place, and the inflexibility of the professions, as opposed to lawyers where you every time must play the devil's advocate, see things from your perspective, your client's perspective, the other parties. So I struggle to see how that could happen. Thank you.
Thank you, ma'am. Louise, you want to respond? Or there's another question. Sorry, Leon. in the front. I think you have a horses for courses argument, if I read it correctly.
Good day, everyone. I'm a lawyer. I would suggest that this could be part of the university curriculum to be added as a module for chartered accountants. And so it's going to be easier for them come to this arbitration and have the knowledge and, an understanding of how to go about it. Yes, from ground root level, meaning that it's from first years all the way up. Okay, thank you.
There's another hand up there, Leon.
Good afternoon, everyone. I have a differing opinion from the lady because I believe chartered accountants as arbitrators is actually a dream that we should all have, and not only chartered accountants, but all other professions as well. Because there are certain levels of expertise that legal persons, as much as we would like to believe we have, we do not have them. And if a dispute were to arise in the finance or finance field, for example, I don't think it would be rational or fair to expect a legal person to, as much as the parties can present their sides and their arguments, that a legal person can then preside over this and actually be able to grasp concepts and so forth and give a meaningful reward. In Namibia, I'm from Namibia, we have, for example, the health professional councils where arbitrations or disputes that arise are arbitrated by health professionals, by doctors, because they have the relevant expertise to do so. A legal person wouldn't know what is a reasonable thing to do or procedure in a certain instance. So I think it's a dream that can be attainable. I don't know which one of the panelists said it, but it would take training to a certain extent on how to arbitrate or how to act as an arbitrator. But I think it's a wonderful dream to have, and I hope that it actually does materialize. Thank you.
So any other comments or views that you would like to share? All right, so I think we are pretty much over our allocated time and into tea, but what I suggest is the panel is going to have tea, and if you want to have any further engagement with them, I think the views that you're sharing are quite valuable, so thank you so much for that. We do appreciate it. And it's still a journey that is still a way to go, and we're not quite sure where that journey is going to take us. I have to say, from a personal note, I am quite relieved that my 2 sessions today is done, because this morning I was trying to convince a room full of lawyers that the next big arbitrator is going to be a machine. And this afternoon I had to try and do it, say that it's going to be CA. So please let me go free out of the building.
Dion, I hope no one believes the machine will be better.
Yeah. But thank you so much for your attendance. We do appreciate it, and we do appreciate the comments. We take it up. Thank you.
Thank you very much. Welcome, everyone. Can we have one door closed, please? At least one door. Advocate Advocate Aiti, wouldn't you please do my timekeeping there, please? Okay. So this session is about a topic in regard to arbitrations, whether, well, specifically commercial international arbitrations, whether such arbitrations unwittingly facilitate corruption. I am your moderator for this session, Pule Seleka, a senior member of the Johannesburg Bar, and I would like to introduce my panel members to you. Next to me is also a senior member of the Johannesburg Bar, Advocate Mohammed Chowen. He is a long-standing member of the bar, a leader of one of the well-established group of the Joburg Bar. He does many of commercial arbitrations and sits as an arbitrator. Next to him is a colleague of mine as well, a member of the Johannesburg Bar, Greta Engelbrecht SC. She is currently the chairperson of the Johannesburg Bar and does a lot of work in competition law. And next to her is a colleague of ours from the Pretoria Bar. He's the chairperson of the Pretoria Bar and also involved in arbitration work. So we welcome them and thank you all. So the topic emerges in the context of commercial arbitrations and is relevant for purposes not only of international arbitrations but also our domestic arbitration law in South Africa, particularly where a defense of corruption is raised, where you have a state party involved in arbitration and raises a defense of either fraud or corruption in order to avoid liability on a contract which is the subject matter of arbitration. Now, there is a recent judgment of the Commercial Court in London that brings to the fore the issues of confidentiality versus public nature of the court proceedings versus arbitration proceedings, where arbitration proceedings are normally held privately and confidentially, and what happens in instances like that versus if an arbitration were to be held in the public domain, accessible to the public and to the media. Now, just to begin the discussion, I want to quote what the judge in that judgment said. It's a judgment that involved the government of Nigeria and a private company owned by two Irish businessmen. And on this issue regarding privacy and confidentiality, the court said the privacy of arbitration meant that there was no public or press scrutiny of what was going on and what was not being done. When courts are concerned, it is often said that the open court principle helps keep judges up to the mark, but it also allows scrutiny of the process as a whole. And what the lawyers and other professionals are doing, and where a state is involved, what the state is doing to address the dispute on behalf of its people. An open process allows the chance for the public and press to call out what is not right. And what we need to also debate is whether, because of the confidentiality and privacy of arbitration proceedings, issues of corruption could be swept under the rug. And there's no scrutiny by the public and the media. So my first question to the panel, I suppose, it's is the defense of corruption one that can be appropriately dealt with in an arbitration setting? And that question, I think, should be considered in the context of our South African domestic law, where our courts have often said that a state organ has the duty to, when it has uncovered corruption in the procurement of an award, of a contract, to bring review application in order to set aside the awarded contract. Is it a matter for the court in terms of review, or can this defense of corruption be appropriately raised in private arbitrations, if they are private, and be dealt with there in confidence and without public scrutiny? Any of the panel members can go forward. Is it?
There we go.
Oh, it's on.
Good afternoon, everyone. Probably good evening as well.
That's right.
I suppose, Pule, your question raises for me two separate inquiries. The first is one of jurisdiction, and the second is one of policy. I say two questions because the question of jurisdiction will inevitably arise when the parties to the contract have pleaded corruption as a defense. So in that particular instance, the arbitrator's jurisdiction to determine the question of corruption will have arisen primarily because of what had been pleaded and what has been put to him. But that's an ancillary question, because ultimately the primary inquiry remains whether, notwithstanding that jurisdiction, our law would permit the arbitrator to determine something which is or ought to have been in the public domain. And we have had instances in our courts before, and there is a judgment that comes to mind in ISO Leisure versus Airports Company, where the judge took a view that the contract, although not based on corruption, but based on illegality, was not one that could be arbitrated and had to be dealt with either in terms of parja or principle of legality by a court. I've not seen an appeal to that judgment. I see Professor Butler sort of nodding, and that seems to me to be the only case that has dealt with it for squarely on that basis. There is merit to that proposition, because at the end of the day, we would like to uphold our state organs at least to a threshold and to public scrutiny, which you do not have in domestic legislation, and certainly not under the Domestic Act. That's different, of course, in terms of the International Act, which contemplates that international arbitrations are public by default, rather than the other way around. It recognizes that there might be state parties involved, not only South African state parties, but international state parties, and perhaps for that reason has included the public platform. But the same does not apply under domestic legislation.
Would that necessitate a change to domestic legislation?
I don't think so, because again, domestic legislation has a carve-out. The Arbitration Act contemplates that a court may, on good cause shown, either declare the arbitration agreement unenforceable. So where you have two parties before an arbitrator and where corruption has been pleaded, it is open for either of the parties to contend before a court that this is not an appropriate matter to be dealt with by arbitration. Ask for a stay, and presumably for the court to determine that in these circumstances public policy dictates that it be dealt with in an open forum.
So would you support the proposition or approach that matters that involve corruption, fraud or illegality be dealt with not in an arbitration but in court?
I would.
Okay. Greta?
Just to add, in the question of the enforceability of arbitration awards, I think is rather central here. We, in this community, I think, want to have arbitrations preserved as a reliable form of dispute resolution. And if there is a risk of unenforceability, so in other words, you allow the corruption issues to be dealt with, but then ultimately allow for the arbitration awards to be set aside, you place a question over the reliability of arbitrations as a mechanism. And I think that it's a significant concern that we should watch out for as an arbitration community.
Yeah.
May I just say, I think there are a number of issues that are implicated in what was said before. To my mind, the moment that a defense of corruption is raised, it effectively is aimed at vitiating the contract. And if that is the case, it implicates a number of other issues, namely jurisdiction as well. So against that background, I think we want... I'm sorry.
No, it's on. Just
must I put it?
Yeah.
I'm sorry, I've never been a singer, so I find it quite difficult. Maybe I should just repeat. I think a number of issues have been raised that implicates a number of different and perhaps separate, although intertwined issues. If one deals with, just on the first distinction, with a defense of corruption and implementation of the contract, I think none of the questions would arise. But once one deals with corruption on the basis that it vitiates the very existence of the contract, because it has come into existence by reason of a corrupt activity, then one firstly must, I think, consider whether the arbitrator on the separation principle, would it all be appropriate to consider the issue of corruption? Because if he does come to the conclusion that it is vitiated the contract, it may very well implicate also the very existence of the arbitration clause. So that's the first thing that I think should be considered. The second is a public interest issue that was raised. When one deals with government institutions and constitutional obligations on them, and there are to be findings of a breach of them, and more in particular fraud and corruption, that immediately implicates public interest. And when that is implicated, to my mind, it is perhaps not impossible in terms of a jurisdictional question, but most certainly I think not advisable that they be dealt with by way of arbitration, and they should preferably be dealt with by a court of law.
I see. But that what we see from that case I've referred to of Namibia versus PID, Nigeria versus PRD. And this is the question I grapple with, or the approach of the court, and I see that also in the arbitration tribunal in Metal Tech, in the case of Uzbekistan, that although they tie the question of corruption with jurisdiction, the tribunal and the court nonetheless went into determining the merits of the case, ultimately to find that they do not have jurisdiction, but have been dealt with the merit of the case. And so I was left wondering, but what is the point if you go to the merits? Is then a question of finding in favor of a defendant who is faced with a claim and dismissing the claim, why don't you just do that if you have traversed the merits, as opposed to if you're dealing with the issue of jurisdiction, you deal with it up front. And do you determine the issue of jurisdiction merely because on the basis of the allegation of corruption? Can you say, well, because a corruption allegation is raised or corruption defense is raised, I do not have jurisdiction and that's the end of it? How does a commercial arbitrator at international level supposed to approach this matter? Is that tribunal correct in that approach, or do you think there's something to be said in order to correct the approach? Because then you sit weeks in that arbitration, weeks on end, only for the tribunal to say, I don't have jurisdiction when it renders its award.
The corruption defense, I think, creates a little bit of a catch-22, because of course the arbitrator must remain impartial, must still evaluate all the evidence, is bound by all of the other rules still. So now the corruption defense is raised. And in order to determine whether or not it is properly raised, and we can deal later maybe with the question of the burden of proof and how the evidence should be evaluated. But without considering the evidence, you can't decide whether or not the claim of corruption is a proper one. And so you have to enter the merits in order to make the decision on jurisdiction. And I think that is the explanation for it.
We're elevating corruption, but there is no difference in my mind to corruption or any other vitiating act to a contract, particularly in the state sector. If a contract is void or invalid because of non-compliance with PFMA or with any other procurement policies, the end result remains the same. We are dealing with corruption because of the severity of its consequences. But the same consequence applies. That is that the contract may end up being void, ab initio. And the concern there has always been that if the underlying contract is void, and consequently any arbitration clause in that contract is then declared void, then the arbitrator has no jurisdiction to determine it. But as Greta says, you only will know that once you've gone through the evidence and determined that question. Which is why I suppose most arbitral rules contemplate the arbitrator determining his or her own jurisdiction.
So yes, you want to add? It seems to me then so whatever defense is raised, if a tribunal is going to deal with the merits of that defense, it seems to me then it's not a question of jurisdiction. Whether or not I have jurisdiction is a question of the merits of the issue. Gerard? I will come back to you, Mohammed.
I think you leave the difficult ones for me. I think one should go about carefully, because it is difficult to take one paintbrush and paint all the same color.
Mm-hmm.
Because as we all know, you have some arbitration clauses that do provide for arbitrators to determine their own jurisdiction. In others, they are excluded. So for present purposes, I assume that an arbitrator can determine his own jurisdiction. And I think, to my mind, if I have regard to what I've said earlier as well, the issue of corruption and the plea of corruption really, I think, touches both on the issue of jurisdiction and on the merit and whether it can be dealt with. Now, if one assumes that a plea of corruption falls within the ambit of that which the parties agreed to be referred to arbitration, and if one assumes that the arbitrator can determine his own jurisdiction, then of course it would not provide a difficulty as postulated by you, because then the arbitrator would, as part of the process, and I think an integrated one, determine the existence or not of corruption, determine the issue of separation of the arbitration clause from the remainder of the agreement, and then both he has jurisdiction to determine his own jurisdiction and to make a finding on corruption. And that, I think we should not forget, always is subject to the supervision of the court. Any such award, if to be enforced, needs to be made in order of court, so that oversight function in terms of our local laws are not ousted. It becomes, I think, much more difficult where an arbitrator cannot determine his own jurisdiction. But then one needs to, on a practical level, I think, approach it on the basis to say that he needs to delve into the merits to determine the existence of corruption or not. And if found to be present, it may oust his jurisdiction. But that then, of course, is the end of that matter and necessary, and I do not think inappropriate at all.
Yeah. And I think, Mohammed, just before you come in, I mean, the question of determining your own jurisdiction as a tribunal or the arbitrator also requires to be unpacked. What does that mean? What does it entail? Because you either have jurisdiction or you don't. And if you don't have it, you can't even begin to look at the issues. And it troubles me that an arbitration will run for a week or 2 or 3, and costs are incurred, counsel are on brief and running the matter, only to determine after 3 weeks that, as a matter of fact, corruption has been established and I have no jurisdiction. But anyway, you wanted to deal with something else.
Yeah, I wanted to pick up on what Gerard had said and perhaps add a rider to it. I suppose it all depends on the relief that is being sought. We're labeling this as a corruption defense, but there are 2 possibilities. Is that where the state actor says the contract has been concluded by virtue of corruption, 2 consequences may flow. They may elect to say that as a result it is a void contract, and consequently the arbitrator has no jurisdiction, in which case it must go to a court. And that's one of those species that would fall under, I think, Section 3 of the Arbitration Act. But there is another consequence, and that is that the state actor is quite happy for the defense to be dealt with by the arbitrator. So having raised it, the defense is not one that is intended to oust the arbitrator's jurisdiction, but simply to declare that any payments, for example, that may have been required to be made are not made. And that, I suppose, depends to a large extent on how the parties themselves deal with it before the tribunal.
I agree with that fully, and that's why I said it depends on the wording of the clause. We know that in the ordinary course, in normal commercial arbitrations, the arbitration clause ordinarily survives any termination or perhaps a finding of invalidity of the contract in order to facilitate it to be adjudicated by way of alternative dispute resolution mechanism. So that can be done and not implicating, I think, ordinarily by the arbitrator, irrespective of his finding ultimately on corruption and whether he vitiates the contract. But if the terms of the contract are such that it would implicate both, then of course one finds yourself in the predicament that Puli had mentioned earlier.
Well, let's talk about this separability principle, now that we've touched on the arbitration agreement or clause surviving the main agreement itself, because we know that's what the international arbitration law provides. Separate the validity of the main agreement from the validity or otherwise of the arbitration clause. But you are aware of the judgment of the SCA, Cameron's judgment. And I think there's a constitutional court judgment as well where a matter that involved the land bank, where the court says the clause, like an arbitration agreement, it's subservient to the main agreement. and its validity is dependent on the validity of the main agreement. So that if the main agreement falls, that clause or arbitration agreement also falls by the wayside. So there's this harmony between our domestic law and international law. And the question is, if you are having an arbitration here in South Africa, dealing with a matter that involves, on the face of it, an invalid agreement, or one tainted by corruption, as was found in that SCA judgment, that the clause should fall. The arbitration clause should fall as well. How should one deal with that?
Pule, I think that judgment, if I can just read out what Cameron J. said.
Yeah.
He said the arbitration clause was embedded in a fraud-tainted agreement which the province elected to rescind. The clause cannot survive the rescission, and the agreement purporting to give effect to it is stillborn. And of course, he then cites Lawser Wayland versus Everett, which is an old authority. I think we've...
By old, you mean it's outdated?
Updated, yes. I think we've moved from that position because recognizing that difficulty, you find most agreements now contemplate the severability and the survivability of the arbitration clause for precisely that reason. Absent that, you would fall back. Sorry, I see a hand. Yes, Professor Butler. I think that's a very good point. If we're dealing with an international arbitration, well, let me put it to you this way. I think there ought to be no difference between a domestic and an international arbitration if you are dealing with state actors that implicate state funds, state resources, and where corruption is alleged. My view is that in those circumstances, those are matters that ought properly to belong in a public forum, in a court. The only caveat that I have to that is that the International Act, of course, contemplates a public hearing. And so, if it's a state act. And so, it... Yes. But that's that is on a public policy basis. Yes. Yes, we're in agreement.
So, Professor, you are saying when it is tainted by corruption?
Yes.
When,
I think that
when the main agreement is tainted?
Yes.
Okay.
That the arbitration clause cannot be used in those circumstances.
I see.
How you establish that corruption is present, whether the court makes that investigation, which I think the court should properly do if the matter is before the court, or whether the arbitrator makes that.
It's an open question.
Yes, but the ISO leisure is still correct on this, and I can, I'll ask for your card afterwards, and I can email you a recent decision where ISO leisure was followed.
Please do.
Thank you.
Please do. Leslie, I think you should also note down your question in regard to the Land and Agricultural Bank where Mr. Shabangu was involved. Because also the Constitutional Court there found a subsidiary agreement to fall by the wayside as a result of the invalidity of the main agreement. There it wasn't an arbitration, but it was a surety agreement, where some parties stood surety in respect of the loan given by the company where they were directors. That loan was invalid, and the court said the surety is also invalid. And that's a Concord judgment. But anyway, Greta, you wanted to say something?
I just wonder, it's this vexed question always of when parties make allegations of corruption, for example, in arbitration proceedings, and you raise that offence. Now, obviously, we have a great concern with corruption and we want to address it, but it may be used to delay, it may be used, in other words, not for proper purposes. There may not be corruption, and the allegations can then be abused. So if we adopt a position that is completely inflexible in relation to an arbitrator at least investigating allegations of corruption, then we open up the door for abuse, I think, and again then affect the reliability of arbitration proceedings. So there must be a via media. We can't take an approach that says once the corruption allegation is raised, then the arbitrator must step back and say this is now a matter for the court, or this must be referred to the court, which then maybe brings us back to the question that you asked earlier: should our domestic law be revisited? And in principle, I think the exclusion of corruption cases from the arbitration realm is not problematic from a public interest point of view. But there has to be proper regulation, and maybe we have to look at the legislation to make specific provision for these types of cases and how it should be dealt with when the defence is raised. I don't have answers, but I can raise the question.
But, okay, so far I think, well, Mohammed, when you started, you were saying you think corruption should be dealt with in court. Are you modifying that?
No, I remain of that view, and the Nigeria case is a good example.
Yeah.
The arbitral panel awarded $11 billion against the government of Nigeria. That's half of Nigeria's 2023 budget. And that was done in a private setting. With an awful lawyer and legal representation.
You can't say that.
I just find that to be quite startling that can be done in a private setting.
Okay.
And can I just add to that? Your topic and the heading of your topic was where arbitrations unwittingly give rise to or protect corruption.
Yes.
I'm not so sure that the use of the word unwittingly is necessarily correct.
Okay.
Because let's just go back one step. The parties to the contract are busy negotiating the conclusion of that supply agreement, but they do so in the context of a corrupt relationship. The relationship commences in bad faith, as it were. That clause that is inserted into the supply agreement is not unwitting in those circumstances. It's designed to overcome the public scrutiny that one would get if one were to go to a court. So I think for those reasons, my view remains the same.
It remains the same. But that seems to be slightly different to your view, Greta. Is that right? You're saying go to arbitration, regardless of the allegation of corruption, because it might be false. Let the arbitrator deal with it.
I'm saying the allegation of corruption alone is not sufficient.
Okay.
And there's been some academic writing about treating corruption allegations, and then we go to the burden of proof and evaluating the evidence. And maybe where the suggestion, for example, is if certain red flags are raised, you can make inferences as an arbitrator on the existence of corruption. So that at the very least, if that prima facie case is made out that allows you to make the inferences, then it should be referred to the court. If that burden is not met, then the arbitrator must continue his or her work, I would suggest.
And we will talk about that burden now. Yes. So just wait for the mic.
Sorry. loud enough.
Yes.
So if we could move to a discussion on enforcement. Oftentimes courts are presented with arbitral awards and asked to make it court orders. And invariably, most certainly in our division, this would often happen on the unopposed role. In circumstances where all the court receives is second-hand information before it makes these awards orders of court. Is there a danger in the present approach, most certainly under our domestic legislation, and what does the panel think are the measures that we could utilize to address it? And perhaps Gerhard, it's a difficult question.
So you want to know what should be the role of the court faced with an enforcement application which is unopposed.
In circumstances where it has no primary information as to what in fact happened in the case.
Yes. Yeah, should the court go into the matter?
But I think that raises once again a consideration of the views expressed with regards to whether matters that involve corruption should be dealt with by way of arbitration. Because what, on my understanding, underlies the question is that the court is then effectively asked on minimal information as to the merits of the matter and the allegations leveled to rubber stamp or to consider to make that award an order of court. And that effectively, I wouldn't say oust the jurisdiction of the court, not by all means, but it does limit the consideration by the court of the real issues. And I wish to weigh in a little bit earlier in answer to that on the debate here as to whether it should preferably be dealt with by way of arbitration, and maybe I should just say what I regard as the elephant in the room. There are a number of debates on issues as to how one should deal with matters where you deal with allegations or defenses of corruption involving government institutions. And there are more than one answer, I suppose, on a number of those issues. But underlying it, I think, is the principal question whether in instances of substantive meretricious or at least prima facie meretricious allegations of corruption against a public sector institution or individuals involved, it is something that ought preferably be dealt with by way of arbitration. I personally think not. And I will tell you why I think so. And I do not think that it is at the moment our position in law, but I think it should be considered because of the fact that the allegations of corruption, if they are at least prima facie substantive, implicates not only public interest, but it implicates the Constitution. And once that is the case, it should be, as a principle, I think, dealt with in public and not in private. That number one. Number two, I think that the court that's properly mandated, also by way of the Arbitration Act, in terms of the Arbitration Act, to make orders of court in regard to arbitration awards, should consider and should solely consider these allegations and make determinations on them. I do not think it can be done otherwise. And I will finish, and I think I've said too much already, but I will finish by saying this. I've been involved, and I think any one of us that are often involved in arbitration proceedings, in matters where either directly or indirectly by way of subcontracts, where the state is the employer or otherwise involved, corrupt contracts are dealt with by way of arbitration. The parties agree on a carefully selected set of questions to be determined to the arbitrator for determination, and one should not underestimate the cleverness of doing that, and effectively sidestepping any consideration of the corrupt activities and ultimately obtaining an award that would benefit either way one or both of the parties. And for that reason, I think it is a matter too complicated to be dealt with by arbitration effectively, and it should preferably by statute be regulated to be dealt with by the courts. The concerns by Greta, and I promised to stop and I didn't. The concern raised by Greta that spurious or frivolous defences of corruption may be raised. I think that is an issue that can be dealt with on a different level than on the principal issue. And it can, to a certain extent, be curbed there. And now I will stop.
Okay. Right. So, so to Ayiti's question, Gerard, you would propose a court to descend into the arena.
Yes.
You would propose that.
I think it illustrates the concerns that I have. Because if you allow the arbitration to continue and an award to be made there, one can hardly expect of a court to do that work again.
Yeah.
They will be presented by the primary facts in the founding affidavit and the award. And based on that, the court will consider whether to make the award an order of court or not. And I think a court should not be limited where these allegations are concerned, specifically with regards to government institutions, to that limited role.
Yeah. Okay, we started, what, some 5 or 10 minutes late. We are at 17:11. Is this our stopping time, or do we have 5 more minutes? Oh, do I have a discretion? Wow, is it unfettered or fettered?
This is very worrying.
Mohammed says it's very worrying. Okay, let's quickly ask Greta, insofar as you would propose the arbitrator to deal with these issues, to what extent, and if you follow the reasoning by Gerard, that the parties cleverly agree on the issues that the arbitrator should deal with, and they avoid these contentious, very sensitive issues, they drop them as like hot potatoes, and the arbitrator smells something. To what extent should the arbitrator, what should be the role of the arbitrator in that regard? Yeah.
I came prepared because I knew my lecturer, Professor Butler, would be here.
Because if I might add to that, the issues of impartiality come in. The arbitrator is he limited? He or she limited by what the parties have referred to the arbitrator? Can the arbitrator traverse issues that he or she reads between the lines?
Yeah. So of course, impartiality is exactly the first point that I also penned down, and we know that this has implications because we know under the model law, we know under the IBA rules on the taking of evidence, that it's for the arbitrator to make certain decisions to limit or exclude the production of irrelevant, immaterial, or unreasonable, burdensome evidence. So that's the one thing. So when there's just a sniff, do you include that evidence? And then there is, on the other side, also the arbitrator's duties. Ignoring corruption, never mind, the parties can decide as they wish between themselves, but the arbitrator has a duty, I think, to interrogate, and must interrogate corruption allegations, because, again, if the arbitrator doesn't, what he does is he risks the annulment or the unenforceability of the arbitration agreement, ultimately. I suppose the Nigeria case gives us an idea of what happens when you ignore that which you should take into account, or you see the problems coming. I mean, in that case, when you see this inept, corrupt, I don't know what he is, but representative, and you do absolutely nothing about it, you place your own award at risk. And I think it is, an arbitrator is duty-bound to investigate or interrogate whether there is corruption, precisely because the public interest also demands it. Because otherwise the arbitrator becomes, not unwittingly again, becomes part of the problem of covering up corruption, I think.
Mohammed?
I take a slightly different view. And it reinforces the reason why I believe matters such as these ought to be in the public sphere. I think arbitrators are circumscribed by their mandate. Absent a defense of corruption, in other words, one where it has been foursquarely raised, if during the course of the proceedings there is a hint or a suspicion that the underlying subcontracts, and Gerard, you're absolutely right, we've all been there, you get a sense that there is an impropriety, but it's not a pleaded case. It's been deliberately hidden away from you. What do you do as an arbitrator? I think the arbitrator is constrained by the mandate. There is no overarching duty on the arbitrator to report, as a judge would, the parties to the NPA or counsel to the Bar Council, for example. Those are powers that a judge has, I think, and an arbitrator does not. You also have the difficulty that once you start straying down that line and interrogating allegations of impropriety, the confidence of parties who are not in a corrupt relationship and who come to an arbitrator to determine private matters becomes somewhat more difficult. So for those reasons, my view is that the arbitrator is by and large constrained. Unless it is a pleaded issue, there is not much he or she can do if there is a suspicion or a hint of arbitration, which is why matters such as those which should then be properly before a public body.
Well, Mohammed, would you, okay, I'm going to close with this. Would you then criticize the approach that was taken by the arbitration tribunal in the Uzbekistan matter, where during the testimony by the claimant's witness, it became apparent that there was activities of corruption, and the tribunal called for more information or documentation to uncover those issues. Is that approach commendable, or would you criticize it? He was.
I had a look at that very briefly, Pranab. I can't work out from what I have read what the tribunal's remit was and whether they were given these extensive powers to do so. At the end, they concluded ultimately that they had no jurisdiction, if I'm correct.
Because of corruption.
Because of corruption. Yeah. So having gone through that process, investigated it, and then determined they've got no power, I would tend to probably disagree with that approach. Yeah. Okay. I mean, if I'm going to go down that road and determine it, I would want to determine the issue.
Yeah, but that's the point I was making.
And that's the difficulty, and which is why your point is a good one. Yeah. That you start off with deciding, is this a matter to be arbitrated to begin with?
Okay. Well, let me allow some questions from the floor. There's one there, and
the question I have is that the discussion this afternoon seems to have revolved mainly around local arbitration or domestic arbitration. We have this week had the charter signed with SADC and AFSA, so we should be receiving within our space more disputes that are going up into Africa, where potentially at least one of the parties may be a non-South African party, and potentially that could be a government party from another state. what the panel has said today, would it make any difference if one was looking at that situation, say a South African contracting party with, say, I don't know, a government in Zambia or a government, say, in Tanzania? Would it make any difference to the views the panel have expressed today?
No. Thank you. Can I take the second question? So if you are somewhere else and not in South Africa, do your views change in regard to which specific item? The invalidity of the main agreement versus the arbitration agreement itself?
Sorry, I just meant generally.
Generally.
Because I've heard the discussion to relate around domestic disputes, and I was just wondering whether the panel felt that if there was a non-domestic party involved,
Yes.
would it change the views that they've expressed? Does it add anything to the mix?
Okay.
Judge Bertelsmann wants to say something.
Okay. They will put it on.
Okay, fine. Good. Thank you. 2 points that I would like to raise.
Yes,
Number one, if there's clear-cut evidence or strong evidence of corruption, there's an indubitable duty on an arbitrator to report that and to withdraw from the arbitration. Because otherwise he makes himself a party caps criminus. And obviously there's a fine line between conviction on the part of the arbitrator, that he is dealing with a criminally tainted arbitration. If that is the case, as far as I'm concerned, he's got no option but to act. And the act is, number one, to report the matter, and number two, to withdraw from the arbitration, because he knows that his award is going to be invalid in any event. That, I think, is the one point. As far as the question of raising corruption is concerned, in domestic arbitration, if the government organ raises invalidity, it has a duty to bring a self-review, which if in arbitration, in a domestic arbitration, the government organ as a plea raises invalidity because of a problem in its own ranks, either corruption or invalidity of the agreement because of failure to comply with public finance or whatever, then the arbitration must be suspended, and that matter must be taken on review to the High Court. And then once that issue has been finalized, the arbitration may continue. There's a very recent judgment by Menkes L. in the acting judge in the Joburg High Court where that process was dealt with. And I would suppose that the same must apply to corruption. If the government organ raises corruption, it is in duty bound to take it to the High Court immediately, and the arbitrator cannot do. But if it is raised as a defense as being corruption on the part of the claimant, and the claimant disputes that there is corruption, then I think the arbitrator is in duty bound to deal with the arbitration until he gets to the point where he's where he's convinced that that plea has substance. And the moment that point is reached, he must either go to the High Court or he must follow the route of reporting and withdrawing.
Well, Judge Bertelsmann, how will that position apply in international arbitrations? So,
well, I think the position must be more or less the same. If you deal in an international arbitration with a matter that is clearly a criminal activity that you're asked to endorse, then surely you can't do that. You must withdraw.
Okay. Well, to all the panel members, there's Drea's question. Does it change your views if you were sitting in Abidjan and arbitrating a matter between a foreign state and a private company regarding oil, and there's corruption involved? Do your views change? They're shaking their heads. No, but we've run out of time. So I'm going to You want to say something?
Yeah,
Sorry.
if I may. Corruption is something that can hardly be settled between a government organ of state and whomsoever would be on the other side. You cannot settle it away. If that cannot be done, then the question in my mind is on what basis can the parties then deal with it by way of alternative dispute resolution. And I wanted to say earlier that as far as I'm concerned, an arbitrator, the moment that he is convinced that there's at least a strong indication, he can by no means continue, because then he becomes part and parcel of the enforcement, having regard to my earlier concern as to what I have seen how cleverly parties do that. The Hosplus matter, it's quite clear that an arbitrator only has those powers that are conferred upon him. He cannot go beyond that. It doesn't mean that he can do nothing when something is presented like corruption in the sense of withdrawing or reporting, but that's a separate issue, I think, to exercising a power in the arbitration and in an award or making a ruling. But I do not think that he can go beyond that which clearly is defined, and I think the Hosplus matter is clear on the point.
Right. Okay, well, having said what you said, it just brings to mind what our International Arbitration Act provides, because it provides for the court to refuse to enforce an arbitration agreement, an award that has been found by fraudulent or corrupt means, but it says it's silent on the main agreement itself. So there is a lacuna there. But anyway, Myron, let me call you forward. We will end the session at this stage. There are many more questions of interest. Sometimes you find that in one country you can, what they call, grease the hands of the others, and yet in the other country that is not permissible. And what do you do when you are an arbitrator, you're faced with the two situations? Okay, please.
Our panel members, and especially Ahiti, for setting up this this venue and this topic. Well prepared, well delivered. You did us proud. As GCB chair, I've learned about protocol, but they've only taught me about protocol when it comes to females. I don't know how to deal with protocol when it comes to male. But as a colored male, I know they must pay us something, and we have to give females flowers. So thank you very much, Greta. Please join us for our next session tomorrow at 12. And it also is a very interesting topic. Thank you very much.
Thank you.